Any mention?
May please, Lordship. My Lord, I beg to mention, my Lord, listing of a new case, my Lord, miss case, my Lord, filed by the state, my Lord.
Regarding?
My Lord, this is a miss case in the PIL, my Lord. The PIL pertains to stray dogs, my Lord. So, Honorable Supreme Court, by an order, my Lord, has directed all the High Courts having similar matters to be transferred to the Supreme Court. However, my Lord, this Honorable Court has passed an order on the 30th of August, directing the RG, my Lord, of the High Court to make an application for retaining the same, my Lord. So, we want for modification of that order, my Lord.
No, for retaining the same before.
My Lord, to be transferred to the Supreme Court, my Lord.
No. The order 30th August says that
to retain the PIL, not to send, my Lord.
Not to transfer the matter to Supreme Court.
Yes, my Lord. So we wanted modification of that order, my Lord.
Okay.
The order was passed in the bench of Justice Dengdo, my Lord. So we have make a mention today, my Lord. We have already filed yesterday, and we have already.
Why the urgency?
My Lord, because tomorrow will be the last working day. So, my Lord, the matter will come after the vacation.
Now there's bench sitting for one matter.
Yes, my Lord.
You have to give notice.
We have already given notice, my Lord.
You have any objection? Before the Supreme Court, how is the matter here different?
No. Well, it's what, as a matter of fact, what we submitted is the larger issue. The matter was pending before this court, Millets, when the matter was taken cognizance of by the larger bench of the Supreme Court. And there, Millets, certain directions had been issued where all matters across the country were now to be taken up by the Honorable Supreme Court. It is in that backdrop, Millets, this observation is there. I don't think that really needs anything.
Then we allow this.
It can be expunged.
But then tomorrow.
My Lord.
Not today.
Item number 1.
They are the applicant.
Have you filed objection?
Well, we've not filed any objection. We've seen this entire matter, to the limited extent of my understanding of this entire application. Miscellaneous application.
Yes.
My learned friends.
Yes.
Well, the two issues. These are seeking modification of the earlier order, in light of saying that there are certain development projects which are to be implemented. And there is a hurdle that's been created under the orders passed by this Honorable Court. Now, if I may just take your Lordships to that particular order, in that very order, it has been clarified that this would not really apply to these issues. If I draw your Lordship's attention to page 41.
41 of the miss case.
Yes. Who are the parties? Now let's have page 41.
Yes.
Well, it's second paragraph. On the submission of the Learned Advocate General, we clarify that this order very necessarily does not cover any case where the central government has accorded permission for forest clearance under the Forest Conservation Act 1980 for any development purposes or any direction made by it for deforestation, afforestation, and so on. So, there's no question of really clogging any infrastructure development projects which they have enumerated over here, and I'll take your Lordships over there.
No, one thing, if I understand correctly, the worry is that, now there's already a system in place with regard to the granting of permissions and how it is we sort, and even for harvesting of
trees,
timber in non-forest areas. Now the thing is that what I think they are worried about is that the directions of this court has sort of supplanted the set procedure.
If I may.
So the thing is that if it's already there and the rules have been framed as per the directions of the Supreme Court, then why should this court also exert itself, to have over and above other
two aspects, the latest report of the latest Indian Forest Report. We've got copies of this. It's a very voluminous report, as your Lordships would be aware. It covers pan-India. Also deals largely with Meghalaya.
It is lowest in afforestation, you mean?
And major in deforestation. So,
they may say 20 things, my lord, but I will
you can understand,
I'm not going to get into a little squabble with the Advocate General. I can understand, he's under a lot of pressure.
Let my friend make whatever comments, but I will not respond. Let him finish and then I will place the law.
What I'm humbly submitting before your Lordships at this stage is, I will file a detailed response to whatever the issues raised over here, because it's a very detailed miscellaneous application that they filed. I've run through the entire application. The immediate concern of the state, if I may just draw your Lordship's attention, may kindly come to page 8, paragraph 5.
Of the
Of the miscellaneous application. On what ground they are seeking a modification of this order?
Should have put an objection by today, Mr.
My lords,
we could have, addressed the matter because it give me enough time also.
My lords, may I kindly have a look at page 5?
Yes.
That is most respectfully submitted that the directions contained in the order dated 9/4/2025 have in effect brought all such development works in the state to a standstill, notwithstanding the fact that the concerned project proponents have complied with the statutory requirements and obtained the requisite permissions. So, my lords, and these are the projects that I can trick your lordships. They've laid down, my lords, what are the projects. Your lordships would find that at page. Well, it's at page 26.
Page 24, 26.
26, my lords.
It starts from 24.
24, my lords, they said these are the subject proper requiring tree felling when permission as per statutory requirements have already been applied. This is where the application has been made. And my lords, next page is, my lords, the larger projects which they're talking about. Shillong Peak Ropeway Project, additional tree cutting permission to be required, tourism complex, construction of Umiam Sports Complex. My lords, they've laid down all these 10 projects. Now, my lords, I would only say that the order of 9th actually does not create an impediment. Now, the argument which is being placed by my learned friend before your lordships is, my lords, that there is already an SOP in place. So, with the SOP being in place, these orders passed by this honorable court are actually supplanting those procedure. My lords,
that is the argument.
My lords, I would say that this would require a little lengthy hearing for my lords, because we'll have to assist your lordships whether even in the existence of rules, whether further directions, my lords, or further cross-check mechanisms can be put in by this honorable court, which in my humble submission, my lords, can be put in, and there are various instances where it has been done.
In your PIL,
I'm sorry,
they have not been challenged. They have not been put,
these rules were never part.
My lords, not really, put your finger on why these rules do not address the situation that is prevailing.
My lords, these rules were never part of the record. They were never brought into.
Why should I bring the law should be known to them?
Like I said, if I may just finish, I'm not in a homely argument every morning, my lords. Then I'll say one, and my learned friend will have to answer that. What I'm only submitting before your lordships is, my lords, that there seems to be this urgency on the part of the state that certain development projects, my lords, are getting stalled because of the directions. That I have pointed out at 41, my lords, it does not get stalled. If you've obtained clearance from the Ministry of Environments, then, my lords, you're precluded from the purview of this order. What I'm only submitting is, my lords, we will, because I've got these reports, and these are by the Government of India, it's not by any third party. Well, as a matter of fact, there's a world organization which also has prepared a parallel report, which is even more demeaning insofar as Meghalaya is concerned, but I'm not relying on that because, of course, well, that's not an official document. The Indian government, my lords, has come up with the Indian Forest Report of 20.
Effectively, is seeking adjournment today to have the matter another day.
I am saying, my lords, that insofar as these projects are concerned,
yes, madam.
Your lordships are saying...
Your submission is that this order of 9/4, correct?
It does not affect
anyway hamper the
development projects
that are
insofar as the state is concerned.
The state is concerned, right?
Because, my lords, your lordships will also kindly appreciate that we are not in an adversarial position in this PIL.
Despite
the object of this is, the object of this PIL is, my lords, for having a green cover in the state for which we are known. Now, unfortunately, as it appears from the reports, my lords, that the green cover of the state of Meghalaya is rapidly depleting.
No,
for whatever reason.
But
so, my lords, the state, my lords, absolutely. So, the state is also, my lords, while we are also looking at industrial development and projects coming up, my lords, that the state is equally obligated to ensure that, my lords, the green cover is not destroyed. So, which is why I say, my lords, there is no abject hurry to dispose of this application, because the committee which is there, my lords, is again a committee formed by them only. There's one additional expert who's there. Applications are being taken up, they're visiting, and in terms of the directions, well, they are passing necessary orders. So that's not really impeding anything. Insofar as development projects are concerned, my lords, this will not necessarily ensure that something is coming to it needs attention of this Honorable Court at this moment, or there's some tearing rush. That's what I'm only saying. We'll file a detailed objection, my lords. I'll bring these reports on record with whatever is the figure, just to show, my lords, that the existing rules, as they say, which, my lords, are holding the fort, may not be adequate for the purposes of ensuring that the green cover is maintained.
Yes.
Because if it is depleting, my lords,
yes,
then there has to be something.
Yes, my lord. Now,
and of course, just one second, please. Just once. Other than that, my lords, there's another issue that this miscellaneous application before my lords itself is misplaced because it is filed by somebody who's not a party to these entire proceedings.
Who is the?
Well, it's the affidavit here is filed by.
But it's part of the state, correct?
yes,
But he's not a party, my lords.
Chief Conservator of Forest, my lord.
He's not the Chief Conservator of Forest.
Yes, Mr. Please see.
He says, my lords, I am the principal Chief Conservator of Forest.
PCCF and how?
PCCF is not a party to these proceedings, my lords. The parties to these
He's
proceedings.
filing on behalf of the state, my lord. Now, all kind of technical objections are being
I'm
raised.
saying.
No, my lord, I will just answer each and every issue raised by my learned friend. First issue is, my lord, that the application should be deferred. Now, hearing should be deferred. He should be given time to file detailed reply. With greatest respect, my lord, because my friend should be fair to this court. Why I say so, my lord? If your lordship will check the order, my friend has taken more than 3 to 4 times for filing objection to the application.
No, we have
yes, my lord, your lordship has seen. So therefore, the party cannot abuse the process of law by saying that give me is most relevant for our purposes, for instant PIL. Permission for felling trees of isolated trees in non-forest areas like homestead, farms, etc. Permission for felling of trees from non-forest areas or homestead or farms may be sought under the provisions of Meghalaya Tree Preservation Act where applicable, and in areas outside the purview of said act, applications shall be made by authorized person for felling of to the divisional forest officer or the chief forest officer of the autonomous district council on such ground as may be applicable, who on satisfying himself that removal of trees justified will grant such permission as necessary within 30 working days from date of receipt of application, complete in all respect. In the event that number of trees requested for such removal exceeds 20 or one holding a year, divisional forest officer of the chief shall forward the application with the recommendation to conservator of forest territorial, who shall record refuse permission for such removal within 45 working days the receipt of the such application by divisional forest officer. In the event of the refusal of permission on part of or felling of trees, with applicant may file an appeal next higher authority, that is conservation of forest, within 30 days of communication of such one. Making of trees allowed to be felled with thereafter carried out by divisional forest officer concerned. However, no permission will be required for felling of trees from homestead and farms for bona fide domestic use or farming. The timber obtained from these areas will not be allowed to dispose of sale by. Procedure for permission of felling trees, my lord, from registered private plantation, and then, my lord, there is a procedure required where each and every aspect, even photographs had to be taken, my lord. If I have placed before your lordship the standard operating procedure, my lord. If your lordship will kindly come to my standard operating procedure, which is also very clear.
That is the next in your case, correct?
Yes, my lord. So, and that is there, my lord. Now, my submission is one, my lord. When there is a...
How do you say now? You just come again to the point that has been raised that this order does not stand in the way of you, of
no,
you,
my lord, even for felling, no, my lord, the order supplant and replaces.
To that extent, okay, fine, but then whether
and this order also, my lord,
stand in the way,
my lord, because
it doesn't supplement, whether it supplements or supplants.
Supplant. It's my answer is, my lord, to your lordship's query is that it supplant. How it supplants, my lord, that rules have framed pursuant to direction of the Honorable Supreme Court. Those directions, they
created another permission,
another permission, and for the entire matter, my lord, is seized by the Honorable Supreme Court. The law declared by the Honorable Supreme Court in Article 141 is binding on all states, my lord. If I can cite one judgment, my lord, on this issue. And I will show the recently this issue was even regarding Meghalaya, my lord, in 2024 T.N. Godavarman judgment also, my lord. Give me one more copy of this. If your lordship will see, yes, this is the judgment of the Honorable Supreme Court, my lord, which says that once the direction is passed And kindly come to paragraph 19, my lord. Because this is a judgment, my lord, on the issue that if the matter is seized with the Honorable Supreme Court, if you'll, sorry, my lord, kindly come to paragraph 18 at page 622. And on next 623, my lord, middle of the page, my lord.
Middle of the page, 623.
Yes, 623, my lord.
Law declared by Supreme Court.
Yes, law declared by Supreme Court shall be binding on all courts. I'm just reading. I know 141 you have read so many times. You are the most learned. A mere reading of the article brings into sharp focus its expanse in all pervasive nature. In cases like this where numerous petitions are filed, my lord, judgment, one appeal is filed, the parties are common, then, my lord, it deals with the entire conspectus of law on this issue. And ultimately at page 625, paragraph 29, the Honorable Supreme Court says, my lord, once direction is passed in these paragraphs, my lord, controlling the entire field, my lord, controlling the entire area.
Only what this court doesn't understand is at that time, why was...
Because what has happened, my lord,
I'm on record that, you know...
Yes, my lord, I'm concerned, sir.
PIL does not need any further consideration because we already have a mechanism in place, that's all.
Yes, my lord.
Now after, you know... After
no, I understand that
you want to rewind
yes, my
the whole
lord.
thing by
Yes,
bringing...
I bowed on, my lord.
You know,
there was some lapse
so
on...
the court
I admit that... Yes, it is... I am...
balance the...
Yes, my lord. With the only I bow down, my lord, that the rules and everything should have been placed.
File an SLP then.
Because the issue is that, my lord, if I go to the SLP also, my lord, the issue will be whether did I place the facts before this honorable court. That is the thing. And once I placed the correct facts, because the scope of PIL initially was confined to, my lord,
let's say go back and to the High Court.
Ceylon and the entire area, my lord. And recently, because my friend, I checked the entire T.N. Godavarman judgment on this issue, my lord, that whether anything has happened or change has taken place. That also checked, my lord. Even Meghalaya's forest definition and everything has been taken note by the Honorable Supreme Court in 2024 judgment, and there is no change of law, my lord, because it is, my friend yesterday created some doubt about the law and all. So I have to see everything, my lord. Yes. And then if your lordship will see this 2024 judgment, my lord, and straight away lordship will kindly come to paragraph 70. Paragraph 70, and if your lordship will see paragraph 70 at page 471.
Yes.
And if your lordship will application of criteria cannot universally be standardized. If your lordship will see last three lines of paragraph 70, my lord. In this regard, it would be apt to consider the criteria parameters formulated by various identify the private forest as indicated in the affidavit filed by respondent 1 to 5, and then your lordship will see the definition of private forest is given in state by state, including, my lord, at the foot of the page of next page at 472, your lordship will find Meghalaya.
Yes.
Meghalaya is there, and then thereafter your lordship will see that there was an issue in this case with regard to definition of private forest and whether there should be change in the definition of private forest so far as Goa is concerned. And the court said, my lord, in paragraph 71, the Honorable Supreme Court in clear terms said that firstly, existing criteria for identification of private forest in the state of Goa are adequate and valid. We are not concerned with this, my lord. But the line which we are concerned with, my lord, the effect would be that even minor development on land concerned, the permission of the government under a FCA Act for landlords would become indispensable. It would be necessary to note none of the states have adopted the criteria because density result in opening of Pandora's box. It would result in a state undertaking task of reassessing the forest in all again and has been settled on the basis of existing criteria. So the ratio of the judgment is, my lord, that you cannot introduce something which is not there in the rules. In because they wanted something in Goa case, they wanted something extra, and that was not accepted by the Honorable Supreme Court. Therefore, my lord, my humble submission is that yes, there was some omission on my part.
Yes, huge omission.
Yes, my lord, that I bow down, my lord.
It's not
Yes.
only
Well, it's just one issue that need to be brought to the notice of this Honorable Court. Well, it's my learned friend here is seeking modification of a certain order. My lords are not dealing with the final PIL as at this stage.
Yes.
So any interim orders which are operating, my lords, would be subject to any final orders that are being passed. So now that they've brought these rules into place, my lords, your lordships would consider it at the time of disposing this matter. Now the other aspect of this matter is, my lords, there is a certain report filed by them on the 20th of June 2025.
Where's that? In the main petition.
Yes, well, it's in the PIL. And I draw your lordship's attention to the orders passed by this Honorable Court.
Next report also.
Order sheet.
20th of June. Then
Which status report dated?
Well, it's 20th of June 2025.
Status report.
Malice. But I'll just draw your lordship's attention. This was filed by them, Malice. Let's post the directions passed by my lords for constitution of the committee.
Yes.
Well, if I may draw your lordship's attention to the order dated 24/6/2025.
24/6.
Malice.
Order sheet now. 24/6. Okay.
24/6.
1 second.
20th, the report is filed. 24th, my lords are seized of the matter, and my lords further directions are passed.
Yes.
Well, if I may draw your lordship's attention to the second page of it, my lords.
Yes.
Last paragraph.
We direct.
We direct the petitioner to file an affidavit, my lords. After that, we have perused the report of the state government dated the 20th of June 2025. According to this report, a state-level committee comprising of 3 members, namely the Chief Conservator Forest, Shillong as chairman, so-and-so, Associate Professor, Department of Basic Sciences, so-and-so, as members, has been constituted to implement our orders to stop illegal felling of trees. Now, well, the direction, if my lords would recollect, was to the Chief Secretary of the state to constitute a committee. Accordingly, my lords, a committee had been constituted. Now, well, it's therefore the arise.
Now I know where that when I tried to for my own tree this order, I was not aware of this order.
Well,
even lopping of branches is absolutely
well, that's what I'm saying. Because under the tree
page
preservation
12 of the report, you can see
may
that.
I just finish, please?
Yes.
Please have a little patience.
Yes.
Well, insofar as lopping of branches and other issues are concerned, including the tree preservation rules, is very specific. That does not need to go through the rigors of felling, which is why I had pointed out yesterday. But what I'm trying to go at here is that the Chief Secretary of the State, has indeed, in compliance of the orders of 9/4, filed an application, complied with that, and a committee has been constituted. Committee has been filing its reports. Now, comes the principal conservator of forest, who, to my limited understanding, is definitely somebody in the hierarchy who's below the Chief Secretary, comes before your lordships and says that no, that order is wrong. Let us do away with it. So the state would also have to come up with a clear picture, We cannot have a situation where they are complying with an order and then coming and seeking modification of that particular order. What I'm only trying to say is, what they are trying to say before your lordships would require consideration at the stage of disposal of the final PIL. Whether, the interim orders are actually, supplanting or, running parallelly to the rules which are already in place, or, the issue of whether these rules at all, adequately address the issue of preservation of trees.
See, that does never come up. That is, this court can't understand as to what, you amounted to leading the court up the garden path.
No, my lord, may I respond? My friend will not allow me to speak.
No, please.
Because he will, after my argument is over, then he will say something new.
I'm not saying
we should have said in
all those
No, only thing is, my lord, I fail to understand the process. When you are making an application, you are arguing your matter. You should place everything, and then I'll deal with this. And when my argument is over, you will come out with new point, which is not there in the initial argument.
Other matters to the board.
Yes, my lord.
What I'm only saying is, Millards, these matters would require consideration of my lords at the final stage of disposal. I don't think we are here at this stage, Millards, to dispose of the PIL.
No.
So, Millards, these are
adversarial with Mr. Paul. It is never adversarial.
Yes.
We are very.
Millards, when the state is more intent on cutting trees than preserving trees, Millards, for certain interests, I don't know what to say.
Interest now, everything.
Right.
Any mention?
Or you have concurrent benches running to break them. Yes. One second. Yes.
This victim mentioned item number 5, Your Worship. Item number 5.
Yes. Main list.
Yes, Your Worship.
Yes. Yes.
Yes, two accommodated to Your Worship. Two
Do you
accommodated
have any objection?
No, I'm not mentioning, Your Lordship.
Do you have any objection?
Or no objection, Your Lordship.
Yes, 2 weeks. Yes. Yes.
Much obliged.
Yes, Mr. Marat.
May I please, Lordship, I beg to mention item number 6, Lordship.
Is it connected to number 7?
Yes, Lordship. 6 and 7.
Yes, Lord.
Then? When do you want it?
Lordship, after 2 weeks, Lordship.
6 and 7, okay. We'll have it after vacation soon.
My Lord.
Yes. Yes.
Obliged.
Much obliged, Lordship.
I'd like to mention item 4, my lord, of the hearing list.
Customs matter. Who is the appellant?
The SLP is still pending before the Honorable Apex Court. One of the orders have been carried on SLP before the Supreme Court, my lord, and the SLP is still pending also.
Is that correct? Okay, then after 6 weeks.
Supplementary list, item number 1. May it please, Your Lordship. Lordship, the issue here is regarding denial of input tax credit, Lordship. Lordship, while I purchased the goods, I have paid the tax. But there was some mistake on the part of the supplier, and that actually that time GST has just come in. It is relating to assessment year 17-18. 17-18 assessment year. So what happened, the portal of the purchaser was not showing that I have paid the tax. Only because of that.
Why have you come by it petition?
Lordship, because they have denied my ITC and passed an order, and there is no GST tribunal constituted till date, Lordship. So all matters are being dealt in by the High Courts only, Lordship. In similar cases, the courts have sent back the matters to consider my
Dr. Muzika.
Fresh consideration, Lordship.
It's only for
denial of that, and that credit is there. That otherwise it will be double payment of tax, Lordship. Now they can see the portal, the purchasers portal, and they can give me the relief, Lordship. In the purchasers portal, it is reflecting now, Lordship.
Where's the impugned order?
Impugned order is at page, Lordship, page 82, Lordship, annexure 9, Lordship. Point number 2, Lordship, page 83.
Yes.
Point number 2, that is the facts of the case. So and so, having GST registration and effective date of registration so and so, presently falling under the jurisdiction of Centre under Tura Shillong, the said noticee had claimed the excess ITC of so and so during the tax period July 2017 to March 2018. Thus, there are contraventions of the provisions of section 16.2, 42, 44 and 50 of the CGST Act 2017 read with so and so. Also, in contravention of section 47 of the CGST, the noticee has not paid late fee of this and this for the GSTR 3B filed for the month of March 2018. This is the order that I filed, but the main points are at page 84, Lordship. 84, 2.3 and 2.3, Lordship, may kindly come. 2.3.
Scrutiny for 2018.
Has Lordship for page 84. Accordingly, on the basis of scrutiny of return for the period 17-18, in respect of the noticee was conducted, wherein it was found that the noticee has claimed excess ITC of so and so amount for the financial period this. Therefore, the said noticee is entitled to pay the differential amount of so and so on account of difference between ITC available as per GSTR 2A, that is the GSTR of from person I have purchased, and ITC availed as per GSTR 3B along with applicable interest. GSTR 3B has been filed by me. So there is a mismatch. All these mismatches were there during that nascent period, Lordship. That's why government has also come up with an circular, Lordship, which is at page 98, Lordship will find.
Yes.
Lordship may kindly come to point 4.2, Lordship, page 101, Lordship. However, it may be noted that for the period 1718, as per proviso to section 16(4) of the CGST Act, the aforesaid relaxation shall not be applicable to the claim of ITC made in form GSTR 3B return filed after the due date of furnishing return for the month of September till the due date of furnishing for month of March 2000, if the supplier had not furnished details of said supply till supplier had not furnished details of the said supply in the form GSTR 1 till the due date of furnishing GSTR 1 for the month of February. It may also be noted that the clarifications given here under are case specific and are applicable to bona fide errors committed in reporting during 1718-19. Further, these guidelines are clarificatory in nature, may be applied as per actual facts and circumstances of each case. So this, if I can show from the portal of the other person that the tax has already been paid, then they may consider my case, Lordship. That is my limited prayer. That
Yes.
Well, kindly see page 82, my lord. Para 2.
Yes.
Any person deeming himself aggrieved by this order may, under section 107 of the Central So-and-so Act, read with so-and-so,
Apply to Judicial Commissioner. That's why I think why you've come to the High Court.
This is an order passed by Assistant Commissioner, my lord. The appeal is provided, my lord. And this is a subject matter which can be dealt with by
my lord, this they verbally informed, Lordship, they depend on High Court order only. That's why many High Courts have interfered and they have passed this order.
No, we can't have that. They can't abdicate the
Lordship may kindly see the order which I have placed.
You've come against the show cause notice.
No, against the order, Lordship. Order in original, Lordship. This is order in original, Lordship. Page 82.
And then even then, why don't you avail first of your appellate remedy?
What happens, my lord, if the original authority passing the order is Commissioner, my lord, then the appeal lies to tribunal. So that is a different scenario. Here the original order is passed by Assistant Commissioner, my lord.
This is passed by
Assistant Commissioner. Lordship will find that at page 97.
But Lordship, the revenue will not lose anything if they reconsider my case. That is the thing. The Madras High Court and many other High Courts have considered.
But then the courts, they restrain themselves from interfering in such matters and must go pay.
Lordship may kindly take up this order which I have placed before Lordship. Lordship may kindly take the order. May I read, Lordship? Lordship, from paragraph 2, Lordship. The petitioner has replied to the show cause notice. However, the respondent has confirmed the demand. It is noticed that the dispute has arisen on account of the variations between the input tax credit availed by the petitioner in form GSTR 3B and auto-populated input tax credit in form
Then why didn't you file the Judicial Commissioner and put on whatever you stated in this petition before?
Lordship, it will be a futile exercise. They do the same thing, Lordship. This will not.
This only has possessive value.
They cannot actually, for the portal purpose, they cannot make an order, Lordship. They do not have the authority to.
It'll be corrected down the line. It's not a question that they will order. Once it's detected that yes, you have not evaded any tax and that the tax has already been paid, GST has been paid. So what remains?
That they may consider.
The only thing for you to consider, what you're asking is for remand.
Yes.
Basically.
Yes,
But then the Judicial Commissioner has a jurisdiction also.
Lordship.
To pass such orders.
Lordship, the Lordship may remand it 2 months time. They will finish the matter, Lordship. Nothing.
Get out of Mazika.
2 months time they will remand back. They'll only see and check and remand back.
No, there's nothing to invoke 226, my lord, in this matter. This is pure and simple appellate order.
But they will not lose also revenue and all. Everything is in there.
It's not a question of you're circumventing the process. That's all.
Well, in that case, I'll have to file an affidavit. I'll have it.
Yes, heard MS Kanal Gopi, Leonard Counsel for the petitioner with so-and-so. You should notice Dr. M. Muzika Then senior or DSI with so and so is present and such. No further notice called for on respondents, right?
CBIC is made a party, my lord. 1, 2, 3, 4. The central board is.
Do we need the CBIC? Is it essential? Is it a necessary party?
No, my lord. They are.
No, I'll represent 1, 2, 3, 4 only. My lord.
Yes, sir.
5 is in my humble submission is not required, but it will unnecessarily delay the matter.
MS. No, not assisted with so and so. So, and Dr. Shah was present. And who does want on respect of response number 124. So, we change 1.5. This after 3 weeks, yes, for instructions, everything is but yes.
Lordship, no course.
No interim orders at this stage.
Lordship, no course till that.
We'll come to the next date. Then come instructions.
Item number 2.
Lordship, there will be vacations, Lordship, till
After vacations, you come.
I'll maybe protected till then, Lordship.
No, I'm so sorry.
Item number 2.
Because you're seeking alternate, you're seeking extraordinary relief. Yes, it has to be very extraordinary.
This and item number 3 is similar, Lordship.
Okay.
This and item number 3.
3 also same order.
So it's done. 1 and 3 are
Same.
different.
What is this?
Lordship, in this is a case relating to export promotion capital goods scheme, Lordship. In that, I have bought some capital goods which I have started the manufacture, but it was during the COVID time. So there is a rule when I buy something under the scheme, they give me a relaxation in the duty. They say that within 6 years, the amount of the machine, the duty that has to be paid, that will be relaxed if within 6 years
You export certain amounts.
you export or you pay to the government exchequer somehow, because that time GST was not into the scene. Later on GST came and slowly, but the production took time, because after when I bought the machine, after that immediately there was COVID times and problems were there. So I wrote to the authority also. But now the one authority which they have, I am aggrieved by the show cause notice, that Lordship may kindly come to page 146. Lordship. In my humble submission, they do not have the power to show cause me this
Why?
notice. Lordship, I'll take your Lordship to that. Lordship, show cause notice under section 14 for taking action under section 11 of the Foreign Trade Development and Regulation Act 1992 as amended, and the Foreign Regulation Trade Regulation Rules 1993 for violation of so and so paragraph, Lordship. They do not have, Lordship, the power, because, Lordship, I am covered by Supreme Court judgment, Lordship.
Why don't have the power?
Supreme Court has said, because they already said that I have not exported. When no export and import is dealt with, this section will not apply, Lordship.
Section 14.
Section 14 and 11. Section 11 penalty will not apply on.
We're not familiar with this act, yes. Okay, the order is already final. You come against show cause notice or final orders?
Show cause notice, Lordship.
Then?
Here, Lordship, here this Supreme Court has dealt with the show cause notice only, Lordship. I'm complete. They cannot show cause me in this, Lordship. I may read the judgment. I'm fully covered by this judgment. Exactly same matter. EP export promotional capital goods scheme, Lordship. In this case also, Lordship.
Yeah.
The appellant filed a writ petition under Article 226 of the Constitution of India before the Karnataka High Court, challenging the imposing a penalty of rupees so and so under the provisions of Section 11(2) of the Foreign Trade Development and Regulation Act 1992. The said writ petition was dismissed by the impugned judgment. A writ appeal against the order of learned single judge was also dismissed, Lordship. Now, Lordship, will come to the Lordship the observations of the court, Lordship.
Submission.
Paragraph 11, Lordship.
Yes.
We have perused the order in original passed by the third respondent, which levied the impugned penalty of rupees so and so. The order in original records that Karnataka Biotics did not comply with the export obligation under the license granted under the FTA Act. Therefore, the penalty was imposed specifically under Section 11(2). Thus, the waiver granted under the rehabilitation scheme is of no assistance to the appellant as it was only of the customs duty. Section 11 of the FTA Act reads as thus, Lordship. Contravention of provisions of this Act, rules, orders and foreign trade policy. No export or import shall be made by any person except in accordance with the provisions of this Act, the rules and orders made thereunder and the foreign trade policy for the time being in force. Where any person makes or abets or attempts to make any export or import in contravention of any provision of this Act or any rules or orders made thereunder or the foreign trade policy, he shall be liable to a penalty of not less than 10,000 rupees and not more than 5 times the value of the goods or services or technology in respect of which any contravention is made or attempted to be made, whichever is more. Subsection 2 applies when any import or export is made in contravention of any provision of FTA Act, rules and orders made under the foreign trade policy. In the present case, there is no allegation made by the respondents that against the appellant's predecessor of making or attempting to make any export or import in contravention of FTA Act, any rules or orders made thereunder, or the foreign trade policy. Under the license granted to the appellant's predecessor, there was an obligation to export finished goods. Same with us also, there was an obligation.
Zero goods exported. You didn't export anything.
No, Lordship, that they observed that page 147 they have written. It is there, Lordship. Page 147. 147, Lordship. In the show cause notice, Lordship. Point number 7. They themselves have observed, where based on the above fact, it seems that the noticee has not exported towards discharge of export obligation. So I was not able to make, because of circumstances which was making it impossible, I was not able to make any export. There was no question of contravention of this act, Lordship. So the penalty under this section will not apply on me.
But why don't you show cause and put and place this judgment before the who's appellate authority? You are appearing for the
Customs.
yes. Customs. Yes.
Lordship, here in this case, we have initially they have filed a case, if Lordship permit me, 157 or 138. They have filed before the Honorable High Court, and we have vehemently object that this case's jurisdiction is under the Meghalaya High Court.
Yes.
Then accordingly, they have filed this case.
Yes.
Thereafter, Your Lordship, we have repeatedly asked them to receive their export obligations documents, which are supposed to be show us to the concerned
Show
authority.
that there have been no exports.
Yeah, 59 page.
59.
Page 59. Why the show cause has been issued on the basis of this request of the documents to the petitioner, Your Lordship. Page 59, request to furnish documents towards fulfillment of export obligations, so and so. As may I read, Your Lordship?
Yes.
As per para 5.4a and b of the handbook procedure FTP 2015-20, 50% of the total export obligations amount has to be fulfilled from the block first to second, fourth year. In this connection, the authorization holders should intimate the regional authority on the fulfillment of the report obligation within 3 months of the completion of each block. In your case, even after the end of the second block year, you have not submitted any documents towards fulfillment of export obligation. You are therefore requested to submit the same evidence fulfillment of export obligations, following which you have to pay customs duty along with interest as applicable.
You mean this letters are far back as in 2018?
Thereafter, continuously it has
There
been.
have been letters and we have been applying, Lordship. It will see in 23 also we
So
replied
from
that
2018, you never provided any information as to whether you mean export or not.
we have provided, Lordship. We have been replying to these letters
Then again,
and till 2023 we have informed in 2019, 2020 the problems we were facing because of the COVID times, Lordship. And this
so you've apprised them.
Apprised
have
them.
You filed a reply to this letter?
yes, Lordship.
You filed a reply?
Yeah, I have filed
Then
a
where they said that they have not made any export?
Lordship, they had filed, but issue remains is that.
Lordship by.
Yes.
Yes.
Yes, you continue.
Go.
Lordship, my thing is that because that time GST was not there, but we could not somehow export the material. The material, the way we expected that there will be demand from outside, there was no demand. But locally, whatever we have sold, we have paid to the government the GST. That time GST was not applicable when I imported the good. After that GST became applicable, I have paid GST 6 times GST I have paid. the amount of value whatever is there. This I have tried to explain, but this question, this issue is totally different from
No,
this
yes,
FT.
what we're trying to understand is that now,
Yes.
as per this foreign trade,
Yes.
you have you have to comply with your export obligation period. Correct. That if you are starting this unit under this taking the SOPs under this whatever scheme they have. So now you have obligation within 5 years to export a certain amount. Correct.
Yes.
So now their case, you understand, is that they have asked you to show materials whether you exported or not, and you have not provided that. Is that correct? What you are saying in other words, like whatever it is, we have satisfied that obligation by payment of GST.
Yes,
that is your case.
Yes, and then the adjudication part, this part they have not come to the adjudication only. They have come directly to the penalty part, Lordship.
But the show cause from what it says, the show cause notice only.
Yes, this penalty part. This is what Supreme Court has held, that penalty.
With respect to the thing
Penalty under Section 11 is not applicable at all on me, Lordship. This show cause notice they cannot issue.
Because
this is without jurisdiction.
Show the court where you have supplied all the details about your how you could not satisfy the obligation which is passed by the Act.
Lordship, that
and
I have.
Where is considered that?
2009.
After considering that, they are still, serving notice of
Lordship,
Section 11
page
upon you.
83. Lordship, may kindly come to page 83.
What is manufacturing? This
bricks, Lordship. Some sort of type of brick, Lordship.
Bricks. Yes. Okay. Yes. Page 89.
Yes, Lord. Page 83, Lordship.
Yes.
I have replied to them that I need an extension. This is in reference to your aforesaid correspondence in connection with fulfillment of our export obligation under the scheme in terms of Chapter 5 of the Handbook of so-and-so. In this context, we bring to your kind notice that due to recent business recession in the country, exorbitant high cost of production and not achievement in optimum production capacity in the factory, due to new workmanship to operate the imported machines, it could not be possible on us to compete the international market price in exporting our finished products in the international market. We hope there is a wide possibility in near future to compete in the international market by initiating cost-effective measures by way of reducing the cost of as well as by achieving optimum production capacity in the manufacturing process. Under the circumstances, we request your good self with a prayer to extend the export obligation period for another term of 2 years. After that, also in 23, also we have replied to them, Lordship, page 91, Lordship.
Where's the Act? Section 15. You have recourse for appeal. You consider the appeal, let them file it.
Lordship, I'll take instructions.
You take instruction, otherwise we are not inclined to entertain this petition.
I may please the Act.
But the Act is here.
Act hai unke
Appeal,
paas.
yes. This orders under the hand of Director General. Oh,
Lord,
sir. Deputy Director General.
Yes, Lordship. Foreign Trade Development Officer. For Joint Director General of Foreign Trade.
The authority is also not.
So even you covered by 15B then. This so-called issued on
15B.
which is the date.
Last date ki date is it?
Tomorrow is the date of hearing, Lordship.
Last date.
Tomorrow.
But then you have to deposit some amount, correct? For preferring the appeal. Yes.
Lordship, this section is not applicable. Lordship may go into that.
See, whatever it is, you have ample opportunity to make out.
Lordship, they may file. They may file the
appellate forum.
Lordship,
We're not inclined. Sorry.
Lordship, at least I may be protected for tomorrow, Lordship. They may file their affidavit, Lordship. I am not entitled. I am not. They cannot issue me a notice
show
under
that,
the.
you see, you have recourse appeal. In in your appeal memo, you put that we have already satisfied the condition that we've already informed and written that we don't have any export. And
Show cause I cannot go against the show cause notice for an appeal. There will be an adjudication, Lordship. This show cause is absolutely against law, Lordship. Section 11 is not applicable.
You see the final order, correct?
It is not the final order.
It's just now you said penalty has been imposed.
Lordship, they are trying to impose penalty, Lordship. They are trying to impose penalty. They have said show cause that otherwise.
You are waiting for this for the respondent number. That is number 4 also.
Lordship.
Yes.
Lordship may kindly see the notice. It is for show cause.
We've seen that, yes. Like it, in fact.
Lordship, I cannot go and appeal against this order. That's why, because it is absolutely against the law. That's why I have come before Lordship.
I understand, Isha, but then why can't they take it up? They will see. If any orders pass, then you still have recourse to come for this court. Yes.
Lordship, after passing the orders, then coming to this court will not suffice, Lordship.
You take instructions. Otherwise, you're not inclined to entertain the petition. Yes, heard MS. Will take instructions, or should we pass the orders? Otherwise, you're not inclined to entertain it. Yes.
Instructions, Lordship.
From your people, whether they will avail of the alternate remedy or you want to pursue. Otherwise, with the tentative view of the court, you already know.
Lordship, may kindly take it after vacations, Lordship.
Okay, yes, heard ML Gopi, Legal Counsel for the petitioner with so and so. You are Mr.
B.N. Gogoi.
B.N. Gogoi. Mr. B.N. Gogoi is present on behalf of response number 2 to 5.
Lordship.
2 to 5. What about Union of India? Oh, you're appearing for number 1 also?
Yes.
All 1 to 5?
1 to 5.
1 to 5. No further notice on the respondents. No notice at the stage for the from respondent.
Lordship, I have bank guarantees with them. All the years bank guarantees are there. Lordship,
at least for... See, the thing that we have to go into merits.
Lordship.
Here we're going only on basic, if there's any violation of your rights, that's all. That is so gross that, yes, that under 226 we will extend extraordinary powers to interfere with issue. But then, from what we've seen, it's
Lordship,
purely procedural, or maybe it might be irregular. Maybe you can say that, you can.
No,
yes.
but Supreme Court has said that only, Lordship. Under Section 11, they cannot issue me a show cause notice, Lordship.
That because they say there's been no export. The thing is that it says
in that case also they were unable to fulfill the criteria.
Now they have to be satisfied that you have not fulfilled or you have given enough materials to show that there was no export. That's all. That is not clear from the materials that I gave before.
Lordship, but they have written in the show cause.
Yes.
Item number 4.
Next matter.
Item number 4.
Same.
Yes.
Lordship, kindly protect me for tomorrow like that.
No, that we can pass orders. Nothing that cannot be undone.
Lordship, tomorrow the hearing is there, Lordship. After vacation, Lordship.
Hearing where? Before
this authority, Lordship. The show cause.
Did you attend the hearing?
Daily list.
You can tell them we filed before the we put a petition there, but no orders are coming as yet. Yes.
Daily list. Item number 1.
Deeply.
Yes, Mr. Ghosh.
But this for affidavit, I'm awaiting instructions while I'm praying for some more time.
Yes, sir.
Extend the interim order.
Yes, I heard Dr. N. Musica and JGI for respondent praise that it allowed further 3 weeks time to file affidavit. 3 weeks enough?
Right.
It is allowed interim order of any shall continue till next date.
Right.
Item number 2.
State has to file an affidavit.
1 second, let the file come.
And the miss is deduction.
Yes, Mr. Ghosh. Who's to argue today?
My lord,
It's for hearing.
My lord, the state has to file an affidavit, my lord, against the miscase which the petitioner has filed, my lord, regarding the deduction.
But that you've already said that you already resolved that issue regarding
My lord,
deduction.
we have,
You already instructed that
my
the
lord,
deduction should not be there.
we have the instruction, my lord, that we can revert it back, but we have to file it by affidavit, my lord. That's us. File an affidavit.
Where's the order that asked you to file an affidavit? Where's the miscase? Okay, sorry, slipped my mind. Yes. Yes. No, that day, Mr. Sikon, you made oral submission that this has been done inadvertently by a parallel authority, and so whatever has been debited from the account of the petitioner will be reverted.
Can be reverted back.
Do you need to put an affidavit, or and you file affidavit then?
My lord, we file affidavit.
Mr. Ghosh, they're seeking time to put an affidavit that whatever amount been debited will be reverted back to your account.
Lord, there is no need for an affidavit. They just have to execute it.
Lord,
it's quite surprising that they need an affidavit to do what they want to do.
Yes, surprising to us also, but if it satisfies them, then
Very well, let them do that.
in the miscase, yes, Mr. Shankar had on an earlier date submitted that the debit from the accounts of the writ petitioner had been done so evidently, and that amount will be reverted. So today he had stopped. But he had also been made to put the same affidavit. Today, however, he prays for further time to file the said affidavit indicating the decision. Yes. Yes. Accordingly, how much? 2 weeks time is allowed?
2 weeks.
Yes.
Lord, I have a short submission to make.
Yes.
My learned friend is on a sub-rebuttal level.
Yes.
So therefore it is at the almost at the fag end of the hearing.
Yes.
Now, if he does not have any further submission to make, then
we can close it.
It will be closed. Yes.
My lord,
I just have to place one.
the next date, my lord.
What judgment is the one?
Just one. Yes, my lord. Very recently, a single judge of the Karnataka High Court had passed a judgment where I had appeared, where an identical issue, a challenge was to a show cause notice issued under section 74 on the ground that the ingredients were not satisfied. And this is one of the arguments that I placed before my lords also, that in this case 74 could not have been invoked because of the flux of the law. And also I was relying upon the GSTC council meeting. Just want to place that judgment. In fact, it's a judgment of 16 July, but it got uploaded about a week back.
Okay.
I was appearing in that. Kindly have the oral order, page 3, the first prayer.
Yes.
Issue a writ of certiorari, writ in the nature of certiorari or any other appropriate writ direction of quashing the show cause notice dated 24, bearing number so and so, issued by respondent to under 74 of the CDS Act as being issued illegally and without jurisdiction. This was the plea that I had taken. This was my prayer. Now, my lord, contention is at para 5.
Yes.
So my contention was, in addition to reading the various contentions urged in the petition and referring to the material record, and senior counsel for the petitioner submits that the required interim show cause notice is wholly without jurisdiction as the foundational jurisdictional fact to trigger invoke 74 existence of willful suppression to evade payment of GST in relation to type 3 test has not been satisfied by the respondent and the impute show cause notice deserves to be quashed. This was the contention. Well, the finding is at para 7, internal page 13.
Yes.
A perusal of the material record will indicate that second respondent has issued the show cause notice under 74 seeking to demand GST on type 3 tests upon alleging that the petitioner, being clearly aware of his GST liability, has not declared and paid appropriate GST on the services provided in connection with the supply of taxable services from July 17 to 21. It is alleged that the petitioner has failed to pay GST liability to the extent of actual GST applicable on the value of supply provided for GMAT test. It is also alleged that the petitioner failed to mention the value of services correctly in the GST filing returns and failed to apply the correct GST rate on the consideration received for supply of services. It is further alleged that the appropriate GST was not properly assessed and paid back to the government exchequer, and the petitioner, with the intention to evade payment of GST, suppressed such facts by not disclosing the same for the period under dispute in relation to so-and-so. Identical allegation as they have made in my case. Then the Lordship had reproduced section 74. I'll skip all of that. We kindly come to para 9. A plain reading of explanation to section 74 will indicate that sine qua non for an allegation of willful suppression under 74 to be made out is the non-declaration of facts or information which an assessee is required to declare in his return or in a document furnished under the Act, or a failure on the part of assessee to furnish information sought by the proper officer writing. It is a specific condition of the petitioner that the impugn show cause notice dated so-and-so under 74 by so-and-so on grounds of willful suppression is illegal and arbitrary, being manifestly violative of law for want of satisfaction of jurisdiction fact of section 74 of the CGST, and that the impugn show cause notice is wholly without jurisdiction or authority of law as the foundational judicial fact to trigger invoke section 74, etc., has not been satisfied. Now, kindly now come to para 17. So in this peculiar fact, what had happened was the information was known to the department. As stated, supra, it is specific contention of the petitioner that the impugn show cause notice dated so also issued under 74 by respondent to on the grounds of willful suppression illegal and arbitrary, being manifestly violative of law for want of satisfaction of the jurisdictional fact of section 74, and that impugn show cause notice is wholly without jurisdiction or so also. I'll skip all of this. Then para 18. The whole concept of jurisdictional fact was dealt with by a judgment of Supreme Court, Corona Limited versus Parvati. Then Milord shifts the pages. At para 19, there is Raza's Textile. Para 19. Another Supreme Court decision. Milord has that, para 19? Yes. Internal page 29, yes. Then para 20, which is at internal page 31, ITW Signot. In fact, ITW Signot is something that I had placed before my lords. Then my lord shifts all of that and comes to para 21. This is the heart. In the instant case, a perusal of the material record will indicate the second respondent had decided the jurisdictional facts in relation to alleged willful suppression of petitioners erroneously, incorrectly, by attempting to vest itself with the jurisdiction 74 of the CGST Act and saddle a GST liability upon the petitioner for the period under discord, which is impermissible in law, and consequently the very issuance of the impugn show cause notice dated so and so under 74 of the CGST Act is illegal and violative of 265 of the Constitution, inasmuch as the impugn show cause notice seeks to realize monies from the petitioner under the guise of tax without the authority of law, and impugn show cause notice deserve to be quashed. Then my lord comes to para 23. Here, their lordships have explained why jurisdictional fact was not satisfied. A perusal of the impugn show cause notice will indicate that section 74 of the CGST cannot be invoked in cases involving the mere omission to pay tax or mere omission to give correct information. This is exactly the allegation that they have made in this case. Without there being any intention to evade the tax, the allegation of willful suppression of appropriate GST not being paid and value of petitioner to mention the value of services correctly in GST at 5A returns and failing to apply the correct GST rate ignores the fact that the very mens rea element of consciously or deliberately suppressing information details for the purpose of evading the payment of tax, which forms the sine qua non of 74, is not satisfied in the instant case. The jurisdictional fact for invoking stringent provisions of section 74 of the CGST Act, that is willful suppression with a weak evade payment of tax, are neither satisfied nor not fulfilled in the impugn show cause notice, which deserves to be quashed on this ground. Then at para 24, Cosmic Dice, this is judgment that I had placed reliance before my lords. And then para 25, another Supreme Court, Eastland combines. Para 26, Anand Nishikawa, another Supreme Court. And para 27, Continental Foundation, another Supreme Court. This lays down the law on this whole suppression, etc. And ultimately, they allow my petition.
Yes.
So I
Yes.
just want to place this judgment.
Yes. You have a copy of this? Yes. It's a minor part. Anyway, do you want to close the arguments or what is your?
The matter may be fixed after 2 weeks, my lord. We'll argue it.
You close the arguments.
My lord, we'll argue on the next date, my lord.
Then, my lord, may keep it on 7th, is subject to convenience, my lord.
7 will be a bit difficult. It's quite long. It's just reopening, so we'll have a.
Week after that.
We'll have it. We'll have it.
13, 15, 16.
16th.
16? Yes, sir. Yes, Miss Case, different order. In the mean case, there's a matter of further hearing on 16 October 2025. Yes.
My lord, may keep it parted, my lord. Yes, my lord.
It's already parted. It's already parted, I think.
Yes, yes.
Already parted.
Yes.
Item number 3. Item number 3.
May it please your lordship.
Yes.
Lordships, the rejoinder has been served upon me just today morning.
Yes.
I need some time to peruse
Anything
the same.
remains in this matter?
Lordship, it may be taken up for final hearing on the next date, Lordship. And if need be, if there is anything in this particular affidavit that needs to be responded, I crave leave that I will file the affidavit way in advance before the next date.
Dr. P. Agarwal submits that she has just received a copy of the rejoinder. She raised the matter in this final hearing after 2 weeks. Will liberty allow to her to bring on addition any points necessary to counter by oral arguments?
Yes, ma'am. Grateful.
Yes, after 2 weeks. Yes.
Obliged, Lordship.
Madam?
It's okay.
Any mention?
May it please your Lordship. Lordship, I beg to make a mention for urgent listing of a miscellaneous application in a pending matter, Lordship,
Which
for
pending matter
tomorrow.
is this?
Lordship, this is the matter regarding the reservation policy that was a non-implementation of reservation for transgender persons, Lordship, in Indian Institute of Management, Shillong.
But then why miscase? Because they don't have any quota, I think.
Lordship,
As per the instructions, there's no quota. It is a policy, of course. Understand that a policy has been framed, but then I don't think the central institutions have yet implemented a policy. Correct?
Lordship, I'm only claiming under the directions of the Supreme Court in the Nalsa judgment,
Of
Lordship.
course, yes, we understand that. No, we won't. We'll have it after vacation. There's no urgency.
Lordships, the academy.
In the meantime, I'll file my affidavit also in the main case.
Because there's no quota. If you've been deprived against a quota that's been fixed for LGBTs, whatever, we understand.
Lordships.
Or transgenders. But then
Lordships,
thing is that-
the academic sessions have already commenced, Lordship. Lordship, may just hear me, Lordship. Tomorrow I'll.
But there's no purpose.
There's no purpose because there's no quota. Because last time I think on instructions
Yes,
submitted that the central institutions have not
They have not
implemented
implemented.
their
Lordships.
policy decision as yet. We understand you're fighting for what rights. I mean, we also appreciate that. But the thing is that if no relief can be forthcoming in the urgent listing, what is the point?
Lordships.
Okay, let it come tomorrow's Friday.
Lordships.
We're a bit pressed for time because
After vacation.
after vacation. If you have any right, nothing that cannot be undone.
Yes.
Yes.
Obliged, Lordships.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 37, Your Lordship. I
Number?
said for 3 weeks, Your Lordship. 37, Your Lordship.
No objection, Lordship.
37. Yes.
Yes. What are the Sangma?
Yes, Your Lordship.
No objection.
No, Lordship.
After 2 weeks, yes.
Obliged, Lordship.
Please, Your Lordship, with regard to item number 42, we've not yet to receive instructions.
Which 42 is it?
This is regarding appointment of the assistant headmaster.
Arbitration.
We had heard, Your Lordship had asked us.
The matter was heard, correct?
Yes, Your Lordship. Some instructions.
What remains?
Some instructions were there regarding the applicability of the regulation of 2012, and some appointments had been made according to them who did not possess B.Ed. So, Your Lordship had asked us
His
to.
case is that some who do not have this qualification have been made.
Have been earlier on.
My case is B.Ed is not required.
Yes.
And this petitioner had no B.Ed degree.
No, B.Ed degree still now have.
He may have now, but at the time of
But it is
appointment, he
not
didn't
required.
have it.
As per fix a date.
Yes.
You take a date?
Oblige, Your Lordship.
On the request of, on the prayer of MSc Yangi BLL to enable her to obtain further specific instructions. This is matter on so and so.
Oblige, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 20. Your Lordship, it's a joint prayer with the petitioners. Let the matter come up after the vacations, Your Lordship.
Yes. You want to request this matter after vacation and so and so.
Obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 18, Your Lordship. Kindly let this matter come after puja vacation, Your Lordship.
Any objection? Objection?
Your Lordship, in fact, there is nothing in the report, Your Lordship.
Where's Mr. Deb?
He's on bereavement, Your Lordship.
In bereavement?
Then after 3.
Bereavement, okay, yes.
Lordship. Oblige, Your Lordship.
Lordship, similar prayer to item number 21 and 22, Your Lordship.
Okay, 21, 22.
No objection, Lordship.
22? Yes.
Highly obliged, Lordship.
Yes.
It's item 34, my lord, after vacation, my lord.
Granville Ali?
Yes, my lord.
Okay, yes. No objection.
Oblige. Deeply.
On the prayers of after vacation. Yes.
It's 36, 37 for the final rejoined article.
36?
37.
35, 36?
35.
You're here
Yes.
for the matter today?
Yes.
May it please, Your Lordship. Your Lordship, I beg to make a mention of one unlisted matter for urgent listing, Your Lordship.
What's the matter about?
Lordship, the matter concerns an order which was issued by the Executive Committee of the District Council, which had asked for a referendum, which had directed the Khairam CMship to hold a referendum in order to elect a new Sardar for Maukanrao village. So, Lordship, the order which was the direction which was given by the Executive Committee was already bad in law and bad in faith as well, Your Lordship. Bad in law because, Lordship, they've asked for a referendum to be held. Now, referendums are not to be held when it comes to selection of the Sardar. And it also is a blatant disregard for the customary practices which are already prevalent.
Tomorrow,
there.
then?
Yes, Your Lordship, tomorrow. Obliged.
When have they proposed a referendum?
We are also pressed for time for that, Lordship, because the referendum is supposed to be held within 15 days since receipt of on 15th of
Is there any
September.
notice for referendum?
Yes, Your Lordship.
In the village?
Yes, Your Lordship.
Fixed on which date?
I have to seek instructions on that, Lordship. But it says that
Suppose it's already done?
It's not done, Lordship. It's not done.
Okay, yes, tomorrow.
Tomorrow. Highly obliged.
Please, Your Lordship, I beg to mention item number 23rd, 23, ma'am. 23rd to 33.
20?
3 to 33, my lord.
It's for disposal today?
Yes, my lord.
My lord, it is a joint prayer from among the petitioners, my lord.
No, what about the respondents? They're not being in a joint prayer with you.
Well, let's fix it after vacation.
After vacation, yes. There's a puja bonus for you. Yes, on the prayer, so this matter of puja. Yes, after puja vacation, yes.
Should I beg to mention item 19? It can come after 3 weeks.
19?
19. Mr. Devnath is.
You're there 19?
Yes, right.
Yes, after vacation, yes. What are the matter?
Supplementary list item number 1.
Yes, Mr. Gentleman.
May it please, Your Lordship. Lordship, petitioner in this matter, my lord, was engaged by the respondent MECL as far back as in 1987, my lord. He continued with his service till about 2018. 2018, my lord, unfortunately, he was arrested on account of a criminal charge against him. He was convicted also of that charge, and subsequently, my lord, in 2021, he was released. He was released from custody. At the time of release, my lord, he still had about 2 months of service left. So he's represented that he should be reinstated. The suspension which he had, which was imposed on him, should be revoked, etc. That was 2021, my lord. Till today, we are still waiting for a response, my lord.
21.
Yes, my lord. He retired. He retired in 2018. 2018, he was arrested, my lord.
After
suspension was imposed.
Okay, this is like
suspension was
in custody at that time.
Yes.
Let me get yes.
Yes, Milord, what I can see at page 21, there is a communication, Milord, by the law officer that I am directed to inform you of the matter relating to your prayer for reinstatement and payment for financial benefits is under process. A formal order in this regard shall be communicated to you at the earliest.
That's 22.
3 years back, my lord.
If your lordship permits, then we can pass an order within a period, time-bound manner.
Yes.
My lord, I think they've waived that right. Let them file an affidavit, my lord, stating the reasons.
Take instructions. Whether
Yes, my lord.
whether it's processed any further.
Yes, my
Yes, heard Mr. S. Jindal, Learned Counsel with petition issue notice. Mr. Pandey present, except if you have all the
Respondent 2 and 3 minutes.
And for respondent 1,
just after. Yes, the level for 1. Just after 2 weeks for instructions affidavit.
Obliged.
Get instructions that letter.
Yes. Obliged.
Yes.
Item number 2.
May I please, Your Lordship?
Get Mr. Hazan.
My lord, here, my lord, the petitioner is the, my lord, was the constable, my lord, in 6th Battalion Meghalaya Police, my lord. He was
Dismissed from service.
dismissed from service, my lord.
Guess who's appearing for the state? Heard Mr. S. Hassan issue notice. MS Ajishila Leonard so present with orders of abundance, no forum to call for. Just after 3 weeks for affidavit. Yes.
Wonderful.
Much obliged, Lordship.
My lord.
Item number
My lord,
3.
please.
Yes.
This copy is for the court, Your Lordship, a legible
So
copy of the rules.
The thing is that the rule says whether it's by interview direct or it's by written,
It is
or it allows for both methods.
interview, direct recruitment, and
Where is that? That's rule 7.5.
7.5, Your Lordship. Where is my copy? Yes, take it, my copy. Oh, I have marked this.
Slash interview.
Slash interview, Your Lordship. That day it was not legible, so we could
It
not.
has to be by direct, first
that
the
is not correct,
written
Your
examination, my lord. Examination / interview, my lord.
Yes.
It is
So they
the
can resort
prerogative
to
of.
either.
My lord, as far as this posts are concerned, my lord, it cannot be by interview, my lord. This is
Your Lordship,
because
even the advertisement states that it is interview / examination, and where is the advertisement? Here, Your Lordship, at page 39 of the advertisement, Your Lordship, of the petition, Your Lordship, para 6.
Page 39. See, Mr. Sinkan, you're saying that is violation. The rules have been violated because.
My lord.
Page 39, may kindly be seen.
Interview / 39 years.
Yes, it says here, Your Lordship, para 6, the final selection recommendation of suitable
They should have
candidates.
objected at that point of time.
They should have done that. This
My
is
lord,
our contention.
initially,
Your
my lord,
Lordship.
we are made to believe, my lord, that these people, they are already serving there, my lord, in the department. So they thought their service will be regularized, my lord. And therefore, my lord, even in this advertisement, page 39, my lord, may kindly see page 6.1, my lord.
Yes.
The third line, my lord, the commission will adopt recruitment through direct interview as informed by the department. Only because of this letter, my lord, they have done it through interview, my lord. And it was made to believe to the petitioner also that, my lord, their services will be regularized.
How can that
Because
be?
it is through interview, my lord.
How can you base
that is.
If I may just come in, I
Please.
for the MPSC minutes. It's the two aspects that I'll just take your lordships to the pleadings of my learned friend. Now let's kindly have a look at paragraph 4 and 5 at page 5. It's absolutely contrary to what my friend is submitting now.
Yes.
Petitioners have the requisite qualification at para 4, Millets, and
Yes.
para 5, and they were called to appear in the personal interview held on so and so, Millets. Then they say the petitioners have appeared in the personal interview on the dates mentioned above. However, most of the questions put to them was irrelevant. So it is nowhere indicated in the petition, Millets, what my learned friend is stating that there's a question of regularization. That's number 1, Millets. The other issues, Millets, as my learned friend was pointing out, Millets, at page 39, under the advertisement, Millets, para 6.1.
Yes.
Your lordships have seen that the commission will adopt recruitment through direct interview as informed by the department by so and so. My lords, this is in furtherance to the rules which have already been placed before, my lords. So having acted under that, my lords, and been unsuccessful at this stage, coming and making a challenge to it.
Misconception that this recruitment was special, to accommodate those people already working in the department.
They have conducted
But
the entire.
prove otherwise.
My lord, entire recruitment process was conducted in violation of the rule, my lord. My lord, I have already mentioned about.
File affidavit.
My lord.
Yes, today, MS.
But as far as the status quo, Your Lordship had granted,
Well,
that
it's
will-
just one issue.
Won't continue.
that will
My
not
lord,
continue.
my lord, if that be the case, my lord, there will be nothing left in this matter, my lord, to go ahead with this.
Well, it's the other
case.
issue is the
My lord,
You have to make a very strong prima facie case to sustain
My lord,
that.
the
See,
entire-
order is just for 2 days. You have to make a very
My lord-
strong prima facie
my lord-
case to sustain, that we continue with interim
My lord, the
orders.
rule says it has to be by a.
It says interview slash examination slash
It is. It
interview.
says examination, my lord. I may read it again, my lord.
interview.
My lord, it says.
What you provided a code last time was eligible copy. Now they've come up with a copy which is legible, and it says examination slash
Examination.
interview. And if the
Examination
request to-
followed by
the
interview,
request
my
to
lord.
the
No, that is
commission
not correct.
also-
My lord.
The request of the commission was for a direct recruitment by way of interview, and so you answered this advertisement. You applied,
My lord.
and then on not being selected now, on a misconception that this was special, interview, conducted to accommodate the people working there.
And this, my lord.
And you can't say that the questions were silly or something. Maybe,
My lord, that
but
is,
whatever
and in
questions the
fact, my
interview
lord,
board
they were
puts,
using
then you
pencil,
will
my lord.
have a-
An entire interview process, my lord, they were using pencil. My lord, may kindly
Using
imagine pencil, my lord. And my lord, may kindly imagine.
Why what's wrong with using pencil?
My lord, they can manipulate the entire score sheets, my lord.
That
if
is
it-
not
that be
part
the
of the
case.
pleadings. That is
And my
casting
lord, how
aspersions
can
on the public service
can it be fair, my
Yes,
lord, to conduct
absolutely. MS take down today.
conduct the
MP
recruitment
Yani
process through
been at
personal
the
interview, my
AG,
lord?
Also, Mr. K. Paul, Senior Counsel, on behalf of the respondent.
Number 3, Your Lordship.
3 minutes.
MS Yang, on behalf of the
1 and
respondent. And Mr. K. Paul, Senior Counsel, on behalf of the respondents number
3 minutes.
3. Have apprised the court that the rules as they stand allow for appointment indirect recruitments to be made either by examination slash interview, and as such the conduct of the interview for direct recruitment by, or conduct of the examination by, conduct of the selection by interview is not violative of the rules as placed. What else you want?
If I can just point out, my lord, 11 clause 2, my lord, may kindly have a look.
Further, the
My
submitted
lord,
advertisement also has clearly indicated the fact that the same was to be by interview,
Person.
and the petitioner at that point of time had never put the challenge.
my lord, 11 clause 2, 11 clause 2 says, my lord.
As such, they are stopped at the stage from raising these.
My lord, my lord, there are so many judgments.
Yes, it may let the affidavit be filed by the
My
respondent
lord.
by the next date. Yes.
The status quo is
No,
not
my lord,
continue,
that
Lordship. The status
my
quo
lord, may
should
kindly
not
see
be-
11 clause
Yes.
2, my lord. I'll just read out. It says, my lord, the examination shall be conducted by the commission in accordance with such syllabus as the appointing authority may from time to time make in consultation.
now
with the-
11
That's what has
Now,
happened.
it is
Clause
very
1
clear,
may
my lord, it
kindly
has to
see.
be by of examination, my lord.
Yes.
Well, it's just one issue. The question of maintainability of this writ petition may be kept open. Because we're saying, Millets, that the writ itself is not maintainable. A, primarily because, Millets, they participated. B, the successful candidates have not been made parties to this proceedings.
We'll submit
and
the
therefore, there's no question of
Supreme
any
Court
interim orders.
judgments, my lord, which says when the entire selection process is
order passed earlier.
illegal, my lord.
Indicated, yes.
My lord,
Question of
only-
Millets, the question
my
of
lord,
maintainability.
there'll be-
Party shall not continue.
My lord, at least till the next date, my lord, because let them come up with an affidavit, my lord. Because there will be nothing left, my lord, if the appointment is made.
Dailies, I don't know one.
They knew, they went into a section, the eyes wide open. This is the question of.
That is true, my lord.
Yeah,
But
then-
but entire selection process
Yes,
is against the
next.
rule, my lord. Obviously.
Item number 1.
This is that EPF, that maintainability, they have questions. So today is for hearing.
Ready?
Yes, Lordship. I have already supplied one judgment.
What judgment?
One judgment regarding that composite order, Lordship. I have already placed before.
7014B. Yes, but you've seen the judgment, Mr. Sen.
No, I have seen. In fact, my lord, I don't know, I have just prepared a compilation. Now, what happened here in this case, briefly, if I can apprise, my lord. These issues touched only by the Supreme Court in High Court Engineering. That is in 2013. That issue for the first time and last time came up before the Supreme Court. Now, Supreme Court.
First time, last time. You mean it's not binding?
No, it is binding. It is binding, my lord. Obviously, my lord. If, my lord, the ratio has been laid down their matter ends. Now, what the Supreme Court, my lord, first thing Supreme Court said, my lord, appeal is a creature of the statutes. Now we cannot provide, court cannot provide an appeal where appeal is not provided, number one. Number two, my lord, they have examined the scheme of the act of this Provident Fund Act, and there first they have referred to 7A. Now 7A, they say, is a power of inquiry, my lord, by the official, where they can determine any dues, principal, interest, damage. All this can be decided, my lord, in an inquiry under 7A. Then in 7A, even if the orders are, separate orders are passed, but if the proceeding under 7A, since 7A is appealable, even if the order is separate order, my lord, court says this is appealable. The next question comes, my lord, admittedly this case, my lord, this is not under 7A, before your lordship. Third question comes, but for some reason if the officers, my lord, they do not do it under 7A.
In that case, they pass different dates, correct?
Yes.
It was passed 70 for you, the orders are passed on different dates.
No, same date.
Order same date.
Thirdly, they say if it is passed separately, my lord, in separate proceeding, not under 7A, then it will depend on the order. And there the court has mentioned, suppose, my lord, one facet, they have used the word one facet of the order is appealable, other facet is not, then it is a composite order. Now my humble understanding, my lord, one facet of the order means, my lord, one order, single order, facet means part of the order is appealable, part of it is not appealable, then appeal will lie. Now here, admittedly, two separate orders were passed. That ratio will not apply here.
One order is appealable, the other isn't.
Yes,
that is your case. Yes.
That is it. Now, my lord, secondly, my lord, I have just prepared a compilations. Following this judgment, my learned friend has referred to all the judgment of Delhi High Court. I am relying. Now, Delhi High Court, my lord, a similar situation came with this some kind of little strange, my lord. What happened? The employer, my lord, there also, my lord, 7Q and my lord, 7Q and 14V decided separately by separate order but common proceeding. Employer, he approached the, my lord, tribunal. He did not go to High Court. He challenged this. Tribunal declined to interfere, saying that it is not appealable since it is a separate order. Matter went before the single bench of Delhi High Court. Now, Delhi High Court, after examining this, in my lord, my humble submission is not correct. This is a composite order as in the High Court. High Court, it never said it is a composite order. So, this is appealable. So, this was in favor of the employee. Now what happened, my lord? An appeal was preferred. Who preferred the appeal? And this was opposed before the single bench by whom? Provident Fund. Now what issue what is my learned friend is canvassing now? Just opposite was canvassed, my lord. I have those judgment. And they preferred an appeal agreed by it. They said no. Even if it is a common proceeding, same summon, two separate orders, it's not appealable. They filed and this has been stayed by the division bench. As on route, stay continues. Thereafter, a series of cases came, including, my lord, a case filed by the Delhi High Court Bar Association. There also this issue was raised. But Delhi High Court, my lord, Bar Association fairly considered that this issue is pending adjudication before the division bench. Now, so far Supreme Court, my lord, has not gone into it. This is the situation, my lord. It is still pending.
It will take some time to hear.
Well, it will take some time.
When?
Whenever, lordship.
Yes, let's the matter for the admission hearing on. You take a date.
Item number 2.
My lord, there is an interim order, my lord.
Interim order.
Your Honor, the interim order also in a separate sheet, Your Honor. That means this is not a composite order also.
See, she's got you there.
Interim order is also in a separate sheet, Your Honor. Much obliged, Your Honor.
Yes.
But this is for admission hearing on maintainability. This will also take some time, no, subject to...
This is not maintainable, I think.
I'll try to satisfy your lordships.
Because how you're person affected?
I'll satisfy your lordships.
Because the elections were held on the 21st of February 2025. And after 5 months, they have come to this Honorable Court, my lords. First order is of 25th of July 2025. The rules, Autonomous District Council rules are, my lords, pretty much clear that if you want to challenge an election, it has to be challenged by way of an election petition, which has to be filed within a period of 30 days. So can you, my lords, after 5 months, institute a writ petition challenging the entire election process, my lords, which happened in February. And the constitutional provisions are pretty clear, my lords. The judgments of your lordship and even the Supreme Court is clear that you cannot challenge the election by way of a writ petition, my lords. So if your lordship wants to hear, I can, my lords, make my submissions today itself, or subject to your lordship's convenience.
How long will you take?
I'll take some time, my lord, because I'm not challenging the election.
You understand?
I'm not challenging the election. Yes, my lord.
It's not the result.
The
So
fair,
that- see,
fair conduct of elections, my lord, and for inquiry, my lord.
That is the thing is that you have to prove your locus first.
Yes, my lord. I'll do that.
Yes.
I'll do that.
And you will have another day. Then see, it's
Yes.
going to take some time, and we have
Yes, ma'am.
bit press.
Yes, ma'am.
Time is on the request of the parties. This is matter of application on council date. Next date, we'll try to finish it off.
Yes.
Item number 3.
I'm praying for a week's time to obtain the status report.
We are appealing for number 2, correct?
For number 1, Lordship. For the police station. Services due on number 2.
Yes. But also on 11th, you haven't obtained status till date.
Lordship, we had submitted a letter, but we have not been responded.
Statement on pure phase 1 will not further 2 weeks' time to obtain the status service upon for number 2. Base is present, we have number 1. Yes. Yes, after 2 weeks.
Grateful, Lordship.
Item number 4.
May it please, also. Lordship, here the respondent number 4 was supposed to.
Lordship, we need some more time.
One second. Where's the list?
Your Lordship, we need some more time. And Your Lordship, I have some more submission, Your Lordship.
Regarding?
Actually, Your Lordship, this matter pertains only with the convening of the Darbar, Your Lordship. And out of the list which we have published, Your Lordship, published by the Darbar, and only 10 people names were missing due to some bona fide reason, Your Lordship. And Your Lordship, I have some small suggestion, Your Lordship, if because we don't have any problem in incorporating those names, Your Lordship. So.
But Lordship, our contention is that it should be as per the voters, electoral voters list, because I might be residing in Shillong and even if you stay in Shillong, still maintain your right to one Darbar.
Lordship, because only these 10 people names are missing, so we don't have any.
So Lordship, my right cannot be deprived, Lordship.
So you take one Darbar then.
Lordship.
10 of you have come for the court.
No, Lordship, but Lordship, I have to take instructions, Lordship, because that is our contention, Lordship.
Yes.
And pleadings are completed, Lordship, and this matter can be fixed for hearing.
No, we won't put it the hearing stage. We will dispose of. It's a matter concerning. You're not filing affidavit.
We are not filing, Lordship, because at the first round of litigation, Lordship, the Darbar Shillong has undertaken to conduct the elections, Lordship.
Lordship, may list this matter after vacation, Lordship. I'll seek instruction in the meantime.
Lordship. Yes, MSA Karshi. The council responded 3 and 4 today has submitted that the Darbar, the petition, the respond 3 and 4 is
3 is the headman and 4 is the secretary.
3 and 4. That is the headman and secretary of Ulkso Wapathaw. Have no objections if the name of the petitioners are included in the list of voters or participants who take part in the Darbar. Like for this submission, Mr. Hard praise that will be allowed to obtain further instructions. The list of publication.
Obliged.
If you 10 people agree with them, take part.
Also, I'll seek instructions. Obliged.
Much obliged, Lordship.
Item
Lordship,
number 5.
just a correction, Lordship. It's reflected as Karim. Karim.
Imshib.
Yes. It's Karim. Much obliged, Lordship.
Item number 5.
May it please your lordships.
Yes.
Lordship, I pray for 3 weeks' time to file the affidavit in opposition in this matter. And the second prayer is the interim order has been taken on the bank guarantees which were deposited by the petitioner. They are due to expire tomorrow. So the petitioners may be directed to extend the bank guarantees for a longer period of time. On the last occasion also they had extended it only for a period of 1.5 months.
3 and 4.
3 and 4, SECL, Southeastern Coalfields Limited.
You had some settlement talks.
In the initial stages it was there, but that did not materialize. So on the last date I had prayed for time to file affidavit. However, it's taking some time.
Why are you not filing affidavit?
Lordship, today is just the second occasion that I'm praying for time.
What about number 2?
Number 2, my lord, I checked the previous orders. Mr. MZ Ahmed had appeared on one occasion.
But then you say Coal India is not a material
yes, Coal India is not a necessary party.
This was only directed against Southern Coalfields.
Yes,
Lord. Eastern or Southern Coalfields?
Southeastern.
Southeastern Coalfields.
Yes, Lord.
Yes. Yes.
Your Lordship.
Yes.
We'll extend the bank guarantee, Your Lordship.
Yes.
And there is an interim order also. May it continue.
Lordship, it is on the bank guarantees only. The bank guarantees are expiring tomorrow.
We will do the needful, Your
Yes,
Lordship.
Mr. MS, Dr. P. Agarwal, Leonard Counsel, response 3 and 4, prays that be allowed further time to file the affidavit. We have said respondent stop here further submits that the bank guarantees have been furnished by the petitioner due to expire tomorrow. He prays that this direction will be issued for renewal for extension of said bank guarantees. Yeah, Mr. Datta. What?
NN Datta, Your Lordship.
Senan Datta appearing for the petitioner. Somebody has no objection. The bank guarantees will be renewed. Stop. On this matter, after 2 weeks.
Lordship, if it could be 3 weeks, Lordship.
Okay, 3 weeks.
Obliged, Lordship.
Interim to continue, Your Lordship.
Yes. Tomorrow.
Item number 6.
Please,
Yes,
Lordship.
Mr.
Please, Lordship. Lordship, I pray for some more time, Lordship.
Who's appearing in this case? You or MSS Lalu?
Lordship, I'm appearing.
Is MECL?
Lordship.
Yes. This writ has been instituted since 17th of June, Lordship. This is the 5th time they're asking for time. No instructions still yet. And he's a delinquent
Lordship, last
poor
chance
employee.
will be given, Lordship.
He's a delinquent employee challenging the DP. Minimal years of service left, Lordship.
How many years of service left?
Just 1 more year.
What's the problem?
They've
Lordship
imposed
is challenging
they've imposed a penalty of reduction of my rank.
Yes, we'll give him one more time. Mr. A. Karwanlang, on behalf of the respondents, has again today has prayed for further time to file affidavit. Mr. Karkarang, on your petition, has submitted this is the 5th.
Yes, Lordship, 5th
time that time has been sought, and further submits that the petitioner is suffering.
Yes, Lordship.
Yes, of interest of justice, for the 2 weeks time granted, it's expected next date the official will be on board. You file it.
Lordship.
Obliged.
Lordship, obliged.
Item 7.
I think learned EGS in the on the slides before the other court.
You want disposal today?
Sure.
You ready to the matter?
My lord.
They're ready.
Your Lordship, state has challenged the maintainability, so they have to start the arguments.
Yes, you have altered remedy.
We want. Well, as far as
wrongful release, huh?
Yes, wrongful release. All these
Your Lordship,
matters
I
can be
have,
taken up before Milos in exercise of
But
section
he has,
64.
he has already, when the matter was taken up.
There's been an administrative wrong.
Already observed that, but
from their end, there's been an administrative wrong from their end, and such decision cannot be taken by a reference court.
okay, we'll post it next date. You come prepared. You are prepared today also.
Yes.
You will just post it out. Yeah. Yes. This is the other request of the party. It is a matter of 2 weeks. And endeavour shall be made to dispose of the matter next date.
Yes. Oh, please.
Will you a bit pressed for time?
Item number 8.
It's on the issue of maintainability.
Yes, Dr. Mazika. What is it?
Just today I received, Mr. President.
Objection to what? What is the matter about?
Well, this is the matter concerning recruitment in the CRPF. My learned friend had pointed out, regarding the territorial jurisdiction.
Oh, yes.
Let them file their
Just today I received it.
Let it come up after the occasion.
Immediately after occasion.
Yes, Dr. Mazika submits the instruction which has been received. It is allowed 2 weeks time to file affidavit. It's after vacation. Yes.
Item number 9.
For affidavit, I'm praying for some more time.
Yes. And Dr. Mazika, the response for further 2 weeks time to file affidavit is thereafter. We'll record your presence, yes.
Item number 10.
Please, my lord. My lord, this is the airport matter.
Yes.
Lordship had directed the learned Registrar General to ascertain whether the files are in his custody or not.
Yes. What note is it?
Lightly. Lightly. And see cover.
Yes, I think, but they are in seal cover.
They were directed to be in seal cover, my lord. So if that is the case, if no orders have been passed, then maybe send back to the concerned court.
Lordship, I think it will have to be sent to the competent authority for assessment.
Right, to the collector.
Yes. This is the one is Bisol Lalu, the other one is Birit Nongrum.
And Adeline
Thapa. These are the three files are here.
Yes.
Yes.
That is correct.
To whom should it go back?
The collector, my lord. Correctly pointed out. Correct, collector.
Even can dispose of the matter today itself.
Lordship.
Yes.
My lord may keep it pending, and
why?
If my lord would consider making it time bound.
Otherwise, if you have any further cause of action, you are liberty to approach the court again. Yes. Why?
Then my only prayer is, my lord, that if my lord could make it time bound, let the assessment be done in a time bound manner. Because
Yes.
it's a 2011 acquisition.
Yes, Mr. Sen.
6 months should be enough, my lord.
6 months.
6 months.
Yes. Mr. Day.
6 months is too much, I feel. Let it be 3 months, my lord. They've not had the benefit of the records for a very long time. 6 months is appropriate. 3 months, my lord, I'll pray for 3 months.
My lord, it's been pending for almost 14 years. And
No,
one of them is
because
a
it's just that because these your specific cases lost their way. They got caught up in the other bigger, controversy.
I understand.
Yes, so that is why.
So therefore,
that also is not like totally the fault of the collector. Yes. Take down office note dated 22/9/2025 indicates that 3 separate records in seal cover have been submitted to custody of Registrar General, High Court of Meghalaya. Stop the file accordingly as follows. Opinion of this month. So as next paragraph, as the files and custody of Registrar General, counsels for the parties submit that perhaps the said records may be remitted back to the collector to allow for fresh assessment to be made based on the same. On behalf of the petitioner, MS so raised that.
Because my friend is not sure whether any assessment was done at all. And I'm not sure, my lord. Whether assessment was carried out by the collector or not, my lord. For processing in that case, my lord. But our name has been reflected there, my lord. So it may say it for processing, my lord. They'll process it in accordance with.
You don't open the seal cover, Mr. J.
Exactly.
We send it back as it is. You will send it back.
But let the collector decide. Yes, I'm also not aware what's inside, my lord.
We're not aware what's inside.
Even me, I'm also not aware, my lord. You cannot pick up something and dispose it off in accordance with law.
Yes.
Assessment.
That's too general. We may say processing then. Let's say process the files in accordance with law.
Yes, sir. To allow for to
Processing in accordance with law.
Processing in accordance with law is this for the SN praise that in that event in 6 months time we allowed
Lordship
the
may
collector
say at
to
the earliest and within 6
to
months.
complete the exercise. No, that's a submission. Yes, on Hill and Council the parties ordered that also is ordered accordingly the 3 records to be transmitted to the collector, Riboy district. Yes, for due process in accordance with law. The same should preferably be completed within a period of 6 months from the date and from the a copy of the orders communicated. Or receipt of records. Yes, matter stands and goes up there.
It's all 3 matters.
Very good.
Yes,
obliged.
Very good.
Item 13.
It's for affidavit.
Lordship, we've just received the instructions for said Lordship.
Number 5. Who's on number 5?
Number 5, my lord.
This is MPSC.
Lordship, this is item number 13, Lordship. I'm appearing on behalf of the state, Lordship. MPSC has also entered appearance on the last 2 occasions.
So, Papa had appeared on the last occasion.
The last occasion, MSBF Karanlang. Are you filing affidavit?
Lordship, we are filing, Lordship.
So what about 5? Yes, MS Shila, let us say, advocate for 1 to 4 and B Karanlang for 5, 3, 4, or further instant affidavit this thereafter and so on.
Deeply.
Much obliged, Lordship.
14.
Lordship, we are praying for some time, Lordship, to file the affidavit. This is the second date for the matter that has come up.
Yes, that's paid for 3 weeks' time now for affidavit instructions. Yes.
Right, Lordship.
15.
Similar prayer, my lord. We just received instructions.
Yes, 3 weeks. Yes.
Much obliged, Lordship.
16. 16.
Lord, kindly grant me 2 weeks' time, my lord. I'll file my affidavit.
What is your grievance?
My lord, non-furnishing of the electoral roll to the petitioner, my lord.
What's happened to the matter of Foreign Tribunal?
My lord, next date has given because we have requested the tribunal.
When's the next date?
Next date, my lord, I seek instruction on that.
Well, otherwise you file it before that.
I'll file.
Because if
Just
what
2 weeks,
he
no?
submits correct, that means he'll be prejudiced when he appears for Foreign Tribunal.
Correct.
Yes,
And he might be pushed back to Bangladesh.
My lord, yes, my lord. The problem is my father and my grandfather's electoral roll is required.
You
my
understand?
Lord. Yes, my
Yes,
lord.
sir.
And
Sir,
rules also specifically stated.
Madam Nomri for praise funds allowed correspondence number
1, 3, 4, and 5.
3, 4, and 5. Praise funds allowed for 2 stand for affidavits.
My lord.
The expected next day after should be on
My lord. Highly obliged.
Otherwise, if you can get the records, you can without it filing affidavit, you can just
Yes, my lord. Dispose the direction to the deputy commissioner election to certified copy.
Deeply.
Hearing 17.
My lord, the matter before the Honorable Supreme Court has been disposed of on the 16th, my lord. If your lordship just have the order for a moment.
For the Bombay High Court, it took how many years?
Not a very long time, lordship.
Not very long, my lord.
Not very long. If lordship see the second page, it's a short order. I'll just read it out, my lord.
Yeah.
We've heard the learned senior counsel for the petitioners and the learned senior counsel for the respondents. We've perused the material on record, including the impugned order in great detail. We find that the impugned order is by way of an interim arrangement which has been passed by the division bench of the High Court. The suit and the counterclaim are still pending and are at large. However, we find, having regard to the issues which arise in these special leave petitions as well as in the suit and the counterclaim, the concerned trial court shall conclude the trial of the suit within a period of 6 months from the date of hearing before the trial court. It is needless to observe that the prospective parties and their counsel shall cooperate with the concerned trial court for expeditious disposal of the suit. The trial court may also endeavour to dispose of the suit as well as the counterclaim within the aforesaid time frame, if necessary, to post it on a day-to-day or week-to-week basis. We also say that the observation which has been made in the impugned order is limited for the purpose of disposing of the appeal by the division bench of the High Court. Yes, yes. Only limited to the injunction. Now,
application.
my instruction is this, that the question of filing for the excise license and the question of launching the products, these are two distinct issues. And we would like to argue only on the question of permission to apply for the license before the excise authorities in Meghalaya. If your Lordship will kindly have it 2 weeks later, they intend to argue this matter.
Well, it's the Bombay High Court's injunction, well, it injuncts them from making any application in the interim.
Yes.
My friend wants to hear the matter, my lords, I have no difficulty, but
just after the pujas,
the division bench has injuncted them from, my lords, making any application throughout India.
Throughout India?
My lords.
The Lordship, just give me some time. In case they choose not to press it, then we withdraw it on the next date. Just right after the pujas, preferably,
that
my lords,
order is there before my lords at the Bombay High Court order. My lords, just read it.
Yes.
Actually, the same thing. Well, this is the injunction till decision in the suit. UTO and ABD shall continue the current status of non-introduction of the products in India.
Non-introduction.
And under the impugned marks, Mansion House and Savoy Club till decision of the suit.
So, introduction would relate to launching of the products, not applying before the excise department.
Post application, well, they can launch.
Non-introduction.
Non-introduction.
How you distinguish non-introduction? And
so once I apply, I get the label license, and introduction will be launching of the product. So if Lordships recall, in the first interim order,
serve if there's an injunction against you, suppose the excise department gives you a license to, well, okay. But if there's an injunction against you in introducing
I understand.
the brand, launching the brands here, then what purpose will it serve?
If your Lordships recall, the original order of the learned single judge was that you may not launch your products, you may apply. Once you have an excise license, you'll have to seek leave from us to apply or launch the products. That is the distinction we want to draw. However, if your Lordships gives us 2 weeks time, we'll take a call on this. If you want to withdraw, we'll withdraw.
The fact of the matter remains, well, it's ideally whatever is the decision in the suit would give them a fresh cause of action to come and apply.
There we are just making it. But I'm under
instruction. Friend wants to hear the matter, well, I have no difficulty.
Just over a brand is so precious.
Well, it's the appearance in the Supreme Court order would probably say it.
Heavily litigated.
Yes, heavily.
Lordship will see the councils appearing also.
The appearance says it all, but it's
premium. Yes. Yes. Mr. SNL, counsel for the petitioner, has produced a copy of the order of the Supreme Court dated
16/9/25.
16/9/2025, when directions have been issued for disposal of the main title suit on the date on within 6 months. However, he submits that notwithstanding the orders of the Supreme Court, he prays be allowed to argue on the
only on the question of application to excise authorities, Lordship.
Application of registration of the brand.
Lordship.
Yes.
If it's convenient to the courts on the 8th or 9th, Lord.
Yes.
I have an objection to what he's saying. It's gone as I have no objection, Millards.
Oh yes.
That may be recorded, my lord. Senior has an objection.
Though Mr. Kapos also has voiced objections, let the matter
8th or 9th, Lord. As per your Lordship's convenience.
For the orders on
8th or 9th.
Yes.
This is October.
I live
8th or 9th October. Nice.
35.
Are you to reply?
Only the rejoinder minutes. I should be done in an hour's time, actually.
Then we have to take it at 2.
Very well, man.
You can have lunch in the meanwhile.
Very well.
Yes. Where's the other side?
The Advocate General said his colleague will be here. He said he will join. He's got a partner. I met him in the court.
Yes. So adjourn for now because we have to rise for lunch.
Very good.
Yes, 2 o'clock.
I'm obliged.
38.
to 41, my lord. These are the connected matters.
Yes.
So this will take some time, my lord.
How much time will it take?
My lord, at least an hour will take, my lord, because here it's a reverting back to nowhere, my lord. Once you once you have regularized me by on the recommendation of the departmental selection committee, and the in the directorate level, the director appoints me, my lord, and work as a permanent member for few months, my lord. Then all of us in total violation of principle of natural justice, just because one joint secretary passes an order, I get reverted back to my casual employee. Now casual employee, to add salt to the injury, my lord, after working for 10 years, I have been given the pay of an unskilled wages, my lord. First of all, I am not a daily wager. Secondly, my lord, I was appointed on a casual basis, my lord. Thirdly, my lord, there was a sanction post on the recommendation of the departmental committee, my lord, and the policy itself says that, my lord, there are three ways I can be regularized, my lord, either by the MPSC, or by the district selection committee, or by the departmental selection committee. I was recommended by the departmental selection committee. Now all of a sudden saying that there's a policy saying that only the cabinet can regularize, my lord, and the joint secretary cannot assert the power, the statutory power given to the director, my lord. Director is the appointing authority. So this will take some time, my lord. But
yes, should I?
After petition, your lordship.
Yes, on the prayer of the parties.
My
this is after 3 weeks. Yes.
After, my lord.
Highly
obliged.
35.
Obliged to your lordship for accommodating us. Mr. Prakash is appearing in the next matter.
Mr. Prakash, yes.
Yes. Well, so I'll try and be very pointed because it's a rejoinder to the learned AG's submissions. Well, it's one of the first points we had made.
1 second, because it was so long ago.
Yes, I'll just give a small rundown.
My notes.
Yes, yes. I'll do that, Mala.
No, I was just looking at it. It was-
I'll just give a short list of dates. So there was a tender floated.
Yes, no, it's all right. Yes,
That's right.
I'm going to AG's.
So the contract date, Malats, is 21st February 2011, and the contract amount was 1303.83 crores. Because much was made about the amount going up and how that is an indication of what they're alleging us with. So the project was to be completed in 36 months from 7/3/2011, but it was completed only on 15/12/2017. Now, Malats, everything happens 7 years after the completion of the project. So it's an admitted fact that they gave us a completion certificate. The bank guarantees was discharged. So there was no complaint at any point in time about any breach of contract or any defect. Defect liability period is also over. So this is one of those contracts, Malats, where it does not stem from the execution of the contract at all. It stems from something else, which is, Malats, the disputes that arose as a result of my claims.
For a collateral proceeding. Not this.
That's right, Malats. There were claims 1 and claim 2. Claim 1 went before a dispute resolution board. Now, the dispute resolution board, Malats, under the contract, we have a choice of one nominee. They have another choice. And there is a neutral person. So these three people, Malats, are not either employees or anything to do with any of us. They're completely neutral body. They accepted my claim 1. And likewise, this happened, Malats, claim 1 was accepted on 25th September 2016 and 19th February 2017. These are the two dates for claim 1 when it was accepted by the dispute resolution board. Well, let's just to also remind ourselves, the Ministry of Road Transport and Highways of the central government, they actually give it to them to execute the project. Because this is on a national highway. So all our bills, whatever bills I raise, has to finally be cleared by the MORTH. So, Malats, even if I inflate the bills, somebody there will obviously check it and recheck it. So, Malats, today to accuse me of corruption has very serious ramifications, because then you're accusing not only the DRB members who agreed with my claim, but you're also accusing officials of the MORTH. So, this has very serious ramifications.
So, last time I remember you said that none of the officials are named.
No, except one former officer of a bureaucrat of theirs, one ex-chief secretary. He's the only person named. Nobody else is named. Well, that's the other fact that should keep in the back of the mind is that although the FIR was registered on September 2024, till date, no progress in investigation. It's 1 year, Malats. Second is, in that FIR, there is no invocation of the Prevention of Corruption Act. So the entire edifice of the whole case, the show-cause notice, is corruption. And the Prevention of Corruption Act is not invoked. Neither against that former bureaucrat nor against me. So, this has to be seen for what it really is. They are trying to make out some case which doesn't exist, even according to them. Which is why I earlier also urged, they seem to have done something in kind of a knee-jerk response. They were faced with a interim award, which they challenged up to the Supreme Court and lost. And they had to give us those monies under the interim award, 75 crores odd. The central government gives them that money to release, but the central government will obviously want to recover it from them. They went into panic. So after the final arguments, these dates are important. I concluded my final arguments before the tribunal on 3rd September 2024. The dates are very crucial, Malats, because our entire cases of malafidis.
3rd September 24.
Before the 3-member arbitral tribunal.
So 1 week the file FIR.
Yes. It's a very concerted move. It's a very, very concerted move to say, now what can we do to stall this?
Yes.
Otherwise, there's no explaining this, my lords. A project which is over in 2017, cross-examination is over in October to December 2023. And during cross-examination, they've seen these very records. All that they're setting out in the show cause notice. If your lordship sees those ledger entries, this, that, all available with them. My witness is in the box. Not a single question put to the witness saying this expenditure that you have incurred for, party or New Year party or Christmas gifts, that this is all actually bribes given to officials. Nothing. No question asked. So, when they're faced with this ultimatum that the tribunal's arguments are getting concluded, what they do is, after 3rd September, when I conclude and they have to start, on 10th September, they register the FIR.
Yes.
And within a week of that registering of the FIR, the show cause notice for blacklist. So there's a sequence, my lords. So it's not as if this blacklisting show cause notice suddenly came. It came as a result of the FIR. The FIR is a result of what's happening in arbitration. They're all interconnected.
So you say that because they knew they were up against the wall.
Up against a wall. And they actually went and told the tribunal, that ultimate last stage, listen, we have registered an FIR. And the tribunal notes it in its award. And the entire thing changes. The tribunal then frames an issue on whether there was corruption, which issue is not there. In the order drawing up the issues for consideration, this corruption issue is not an issue at all before the tribunal. On its own, the tribunal puts out an issue saying, was there corruption? And answers it in the affirmative. And now they go around saying, oh, see, 3-member tribunal has already said there is corruption. Well, that was not argued before the tribunal. No evidence was laid before the tribunal for corruption. And no issue. If there's no issue, how can the tribunal pronounce it?
Blacklisting.
That's right. But for what is happening is they're using one for the other. They're using the FIR to say, listen, crime has been committed. They're using the arbitral award, which has followed this event, because arbitral award's date is 12th December 2024. And the next day we get the blacklisting order. So today when the learned AG argues, he repeatedly refers to this factum of registration of the FIR. He refers to the... Yeah.
Blacklisting order date is 3rd of December.
3rd of December. Right, 3rd of December. And then 12th December is the tribunal's award. He uses the tribunal's award to justify the conclusion they're drawing for the blacklisting, which is strange because this happens later. So, they're all interconnected. That's point number 1. The show cause notice refers to 2 provisions. We did not suggest those provisions. They suggested it. They picked up 2 provisions. One is clause 37 of the instruction to bidders.
And clause 59.
59 of the general conditions. The learned AG somewhere during his arguments realized that neither of these clauses apply. Because instruction to bidders is at the time of bid. Bid is over, contract was awarded, contract executed, everything done. So neither of these clauses.
And you say there's no breach of contract also.
There's no breach of contract. No, at no point in time have they raised any demand for breach of contract. We are the ones raising a claim against them, which they are now resisting. So they have now even challenged Mullers in the 34. We have challenged in 34 the negation of our claim 2. They have now filed a 34 challenging the claim 1. First thing which went up to the Supreme Court and got affirmed. Anyway, that we'll argue before that appropriate court. The point I'm making here is, neither of these 2 clauses apply. So what does the learned AG say? He says inherent power. In the contract, there is an inherent power. My point there is this, you can't cite some provision in your show cause notice. And when we challenge the order in the show cause notice, you can't turn around and say, I'm abandoning these 2 clauses. Because which means you did not apply your mind when you issued the show cause notice. Or when you pass the order on the show cause notice. In my reply to the show cause notice, I have clearly told you these clauses don't permit you to do that. Nevertheless, you override me and say, no, these clauses permit me to do that. And you don't refer to this inherent power at all. When I'm challenging you to come up with this inherent power. Now, on a demurrer, I'm saying, even if you say inherent power, you can't have a misuse of that power. On that, there's a very recent judgment, I'm sure my learned friend is also aware of it, of the Supreme Court of February 2025, which goes by the name of Techno Prints versus Chhattisgarh Book Society, Textbook Corporation. Yeah. Techno Prints. I have it. Yes, Justice Pariwala's judgment. I won't trouble your lordships to reading all of it. But what is important is it refers to Kulja Industries, which my learned friend places heavy reliance on, if your lordships will recall. Para 25 may I read, my lords. This court in Kulja Industries, para 25. Is only for the legal part, my lords.
Yes, this court.
In Kulja Industries, reported so-and-so has made pertinent observations as regards the power of an authority to blacklist a company on the basis of the terms of the underlying contract. In the said case, Kulja Industries contractor was blacklisted by BSNL authority on the allegations of having obtained fraudulent payments from the authority. This court of the said case set aside the order of blacklisting passed by the authority as it had the effect of permanently affecting the business of the contractor. This court identified the limits of the powers of statutory authorities to take coercive actions against companies. This court, after examining the terms and conditions prescribed in the tender document relating to disqualification and blacklisting, observed that the power to disqualify a contractor was provided for in the tender document, and such power could be read as an inherent power, and in terms of the same, the authority would have to show that the supplier, and this is important, you have that power, but what do you have to show? A, the supplier habitually failed to supply the equipment in time. B, the equipment supplied by the supplier did not perform satisfactorily or not of a particular standard. Or C, failed to honor the bid without sufficient grounds. None of these are the allegations in my show cause notice. These are not the grounds. It doesn't stem from actually the performance of the contract. They say, yes, you performed it very well. We have no complaints about your execution. We have in fact returned your bank guarantees.
Yeah.
Not a whisper of any defect. Para 26. Undoubtedly, Kulja Industries looked into the final order of blacklisting passed by the authority concerned. We are still at the stage of show cause notice, but they still make comments. However, what is important to note are the aforesaid three guiding situations or grounds on which the authority may be justified in exercising its power to blacklist the contractor. This court in the Blue Dreams Advertising Private Limited versus Kolkata Municipal Corporation, while quashing and setting aside the blacklisting order, as affirmed the High Court, in almost identical facts observed as under. In case there exists a genuine dispute between the parties based on terms of the contract, blacklisting as a penalty cannot be imposed. The penalty of blacklisting may only be imposed when it is necessary to safeguard the public interest from irresponsible or dishonest contractors. And 3, corporation being a statutory body have a higher threshold to satisfy before passing such blacklisting order, and therefore measures undertaken by it should be reasonable. I will pause here for a minute. My learned friend would want to rely on clause 2. He will say this is a dishonest contractor. But the conclusion can't prejudge the whole issue. If my lord reads the show cause notice, they've already made up their mind that I'm a dishonest contractor. They have no evidence to back. Well, they have not filed a charge sheet in that criminal case. Well, the highest form of investigation could be a criminal investigation, because this is a crime. Also, if I have bribed officials, it is a clear crime. Attracting the provisions of the Prevention of Corruption Act, they don't invoke it. Even assuming there is some provision in the IPC which they are invoking 420 and all of that, there must be some investigation. There is no investigation. For 1 year you don't have. Well, so it's easy to make an allegation, but very difficult to substantiate it. So this clause 2 is not to be casually used, because clause 2 has to be read with the threshold part. Your lordships have to be told there is substantive material available, which we have inquired into and which we find supports this allegation. Today, what do we have? Well, some entries in a ledger. We have entries in a ledger for which questions could have been asked to people who maintained that ledger. No questions were asked. Well, this is so important. And now they say, long after that cross-examination is over, when we went through that evidence again, it suddenly occurred to us that this was bribery had happened. With greatest respect, I say, Malats, it can't be cart before a horse. Can I just say this, Malats? I think they bit the bullet too early. This blacklisting bullet should have been bitten after the criminal investigation went to a certain stage. But now it's, Malats, they've now exposed themselves before us, saying we've already made up our mind. We're using this FIR just for the sake of an FIR. We have anyway got the tribunal to negate your second claim, and we'll anyway foist a blacklisting on you. This is an already prejudged, pre-made up mind. This is a sole...
The objective is only to frustrate the award.
Absolutely, my lords. Absolutely, and give themselves some ammunition to continue doing it. So, my lords, this is actually a misuse of a power and authority. The greatest respect. Your lordships will not permit it. That's why I say it's a malice in law, because it's a misuse of a power that you have. You go on saying I have an inherent power under the contract, but how you use that power is very important. Now, if I just read para 29, it's also relevant for us. However, what is important for us to say is that when there are guiding principles explained by this court as to when and in what circumstances a blacklisting order can be passed, then, in our opinion, such principles should also be borne in mind by the authority at the time of issuing a show cause notice. We say so because in the facts of a given case, like the one on hand, on the face of it, it could be said there was no good reason for the authority to issue a show cause notice calling upon the contractor why he should not be blacklisted. Why ask the contractor to face proceedings when applying the aforesaid principles? The issue of show cause notice would be an empty formality. Well, I already invoked this in my opening arguments. We are saying all this keeping in mind the peculiar facts of the case. Therefore, the authority is expected to be very careful before issuing a show cause notice. It is expected to understand the facts well and try to ascertain what sort of violations said to have been committed by the contractor. As noted above, there is always an inherent power in the authority to blacklist a contractor, but possessing such an inherent power and exercising such power are two different situations and connotations. There may be a power, but there should be reasonable ground to exercise such power. To put it by way of an illustration, the police has the power to arrest, but it is not necessary that in all cases arrest must be effected. The police should know whether at all arrest is necessary. We may put it in a slightly different way. Take for instance the show cause notice in the present case is the final order of blacklisting. The final order in any case cannot travel beyond the show cause notice. I request your lordships to underline this, because I am going to argue this very thing. What they set out in the show cause notice, what we find in the final order, is an improvement of the show cause notice. It takes another period into account, another set of entries into account, which was not put to me. Whether it makes out a case for blacklisting, this should be the test to determine whether it is a genuine case to blacklist a contractor or visit him with any other penalty like forfeiture of NIMD, recovery of damages, etc. We say so because once an order of blacklisting is passed, the same would put an end to the business of the person concerned. It is a drastic step. Once the final order blacklisting contract is passed, then the contractor is left with no other option but to go to the High Court invoking writ jurisdiction under 226 of the Constitution and challenge the same. If he succeeds before the single judge, then it is well and good. Otherwise, he may have to prefer a writ appeal or LP as the case may be. This again would lead to unnecessary litigation in the High Courts. The endeavour should be to curtail the litigation and not to overburden the High Courts with litigations of the present type, more particularly when the law by and large is very well settled and there is no further scope of any debate. Then Eurasian, well, I'll read from the second line. Given the nature of such an order and the import thereof, it would be unreasonable and arbitrary to visit every contractor who is in breach of his contractual obligations with such consequences. There have to be strong, independent and overwhelming. These adjectives carry a lot of meaning, my lords. Overwhelming materials to resort to this power given the drastic consequences that their order of blacklisting has on the contractor. I would submit with all the strength that I can muster that in the present case there are no materials at all for this drastic step. The power to blacklist cannot be resorted to when the grounds for the same are only breach or violation of a term or a condition of a particular contract, and when legal redress is available to both the parties. They have started the criminal law process. By all means, let them pursue it. But to say that I have now registered an FIR, now I can go ahead and blacklist you, is this other drastic step. Else, for every breach or violation, though there are legal modes of redress and which compensate the party like the corporation before us, it would resort to blacklisting and at times by abandoning or scuttling the pending legal proceedings. This is exactly what is happening. They have an arbitration proceedings, they want to scuttle it. In fact, successfully scuttled it, I would say. Before the tribunal, they went, showed the FIR, and the whole course changed. Plainly, if a contractor is to be visited with the punitive measure of blacklisting on account of an allegation that he has committed a breach of contract, the nature of his conduct must be so deviant or aberrant so as to warrant such a punitive measure. A mere allegation, well, this again I would emphasize, a mere allegation of breach of contractual obligations without anything more per se does not invite any such punitive action. So, well, let's again, I may just read this for completion. Usually, while participating in a tender, the bidder is required to furnish a statement undertaking that it has not been blacklisted in any institution so far. And if that is not the case, provide information of such blacklisting. This serves as a record of the bidder's previous experience, which gives the purchaser a fair picture of the bidder and the conduct expected from it. Therefore, while the debt itself may not be permanent and may only remain effective for a limited predetermined period, its negative effect continues to plague the business of the debarred entity for a long period of time. As a result, it is viewed as a punishment so grave that it must follow in the wake of an action that is equally grave. Well, this is, I think, the most authoritative pronouncement so far on what it means to be blacklisted in business. And I was sitting down with the clients, my lords, every time, even today, when they bid for any other contract, they have to say, are any proceedings pending? So even if they enclose your lordship's stay order, that shows that there are proceedings pending, and then they're not touched with a barge pole. So they said, well and good, you got an interim order, but we are not able to bid. It's got very drastic consequences. So, my lords, on this inherent power, even if a lordship accepts his argument that there's an inherent power in the contract, as explained in Techno print,
but circumstances
do not warrant it, and it has to be exercised in very grave circumstances, not mere allegations. Untested, what I said this, my lords, untested material. I have now found it, I am declaring you dishonest. That's what it means. Unilateral. Now there are 3 other judgments, I won't read them, my lords, I'm just citing them. These are of High Courts. One is of the Punjab and Haryana High Court, Messrs. Floral Electrical, we'll just hand over the copies, my lords. Floral Electrical Private Limited versus Haryana Vidyut Prasaran Nigam, sorry. And Allahabad High Court B Mark India Limited versus State of UP. You have to give him I won't read them, because more or less they reiterate the same principles. And the Blue Dreams has already been adverted to in the Techno print.
The Blue Dreams is a...
Yes. So, my answer, therefore, to the learned AG's contention on this is that he will still have to show that there was application of mind, there were materials that were tested even prima facie to substantiate this very serious allegation of bribery. As I also pointed out, the wording of the show cause notice itself, which discloses a completely closed mind, which leaves nothing to imagination, because they've already made up their minds.
But what about the argument that the proceedings are based on the admission made by you itself? That is, I think, one of the arguments.
That
will cloak them with that, that is not based on any, collecting any information from. It's based on admission made by.
There's an admission made to them.
Admission made to them.
That's right.
That is the only thing.
So that is not even tested anywhere.
On that, whether that will warrant admission made by.
No, that's what I'm saying. That admission made by him should have invited the Prevention of Corruption Act. If it's an admission, their investigating agency. 1 minute, sir. Their investigating agency seized of it. If it was so simple, by now they should have filed a charge sheet. I'm assuming even in FIR, if they didn't mention PC Act, by now they should have sought sanction. Nothing has happened. Not even a first move made. So they're not serious about it. My question is this.
No, one part of the argument which, it's is that they have achieved their purpose.
That's right.
Scuttling the entire proceeding,
Correct.
avoid payment.
And prejudicing, my lords. Actually, what has happened, they've prejudiced the tribunal. They've prejudiced the tribunal. And, well, it's so casually used, this power, which is why the Supreme Court is reminding us it's so drastic a power. You can't use this kind of a power so casually. If my lord reads the show cause notice, already you can see that they've made up their mind. There's nothing left to imagination. When they come to the final actual order on the show cause notice, they add more material. They refer to one more period, which is not there in the original show cause notice, and very perfectly deal with my replies. My reply is just dealt with for the sake of being dealt with. So, my lords, it's already prejudged, which is why I'm saying, my lords, this is not a fair procedure.
That's why they're starting with the premise of doing already.
Yeah.
They don't need to make any further inquiry.
Correct.
Review the admission. That is their stand.
That's right. It's not by any of us. Well, I'm the one facing the consequences. Somebody else admits on my behalf. How can I?
According to them, we're the one who made admission.
So it's not even like a statement of a co-accused. You're not even at that stage. Exactly. So untested material, simply their own former bureaucrat, and he's not named as an accused. It's just so interesting, Malas. He's not yet actually charged. No charge sheet filed. In the column of accused, at that stage only you can say some person is accused. Till then, everybody is only a suspect. Your Lordship knows that so well. So they're not going to that stage at all. Well, and for bribery, let me ask myself. There has to be two persons, one offering, one receiving. Who's the person who received? All the bribe was not chief engineer. Everything is put on chief engineer. One person. Well, the AG knows how the system works.
Junior engineer is also named.
I'm saying, Malats, this is all an afterthought. Complete afterthought. Some 7-8 years after the contract is completed, Malats. That time gap should be very important for us to note. Because even all these case law that I'm reading, Malats, even Technoprint, that show cause notice happens either during the execution of the contract or soon after. Not like this.
Your case is not a breach of contract at all.
No, I'm saying even the allegation of bribery, you're making it 7 years later. Well, it's extraordinary. It's really extraordinary. And when did you know it? After you filed your evidence. I filed my evidence. You've cross-examined my witnesses. Even then you did not wake up. So, your Lordship should not accept this as an explanation. It's my earnest endeavor that this kind of an abuse of power.
I thought to hear a submission on that part, because it's.
Yes, he made much of it. Correct. So it is not. With the greatest respect, I would first say it's not an admission in the eye of law at all. It's an admission made to them by a statement which is yet to be tested by their own investigating agency. Second, if it is a serious admission, that man should have been proceeded against the Prevention of Corruption Act. They've not done that. They should have sought sanction by now for his prosecution. They've not done that. If he himself is not yet being proceeded against for bribery and corruption, whatever admission he may have made, how do I come into the picture? I am supposed to have bribed him. So, your Lordship should not accept this as any kind of an explanation for what they're doing through the show cause notice and ultimately through this blacklisting order. I don't want to take your Lordship through that cross-examination. I've done that because that will actually be tested by that court. I had referred to it only to say that they had an opportunity. Even to say, okay, during cross-examination, the witness admitted he had paid a bribe. It's not put to the witness. The word bribe is not used anywhere in the cross-examination. So they know that they are now grappling in thin air to produce some material to justify the blacklisting order. I would respectfully submit, Malas, there is actually no material for this blacklisting order, and your Lordships will be fully within the bounds of Article 226, particularly after Technoprints, to say that this kind of a blacklisting order should not be permissible in law to be used. This is a very drastic power. It finishes off businessmen. Malas, I have completed successfully a project for them 7 years ago, Malas. Till date, not a single complaint that any stretch of that road went bad and therefore you will be held responsible. Nothing. What am I here for? Only to execute that contract. You find fault in my work, I can understand. Not this. But as a result, what's happening? I can't perform a similar quality of work anywhere else. You're preventing me from doing it.
No, the JV doesn't exist anymore as of today.
No, so the JV exists, my lords. The person in charge of one of the entities is different. The entity in charge of one of those entities, and we've explained it in a rejoinder in quite some detail, we've annexed those resolutions. The JV does exist. Those entities exist. Those who've taken over that entity, they have changed. It's been sold as a going concern, so a new management, a new entity has taken over that entity. So in the eye of law, the JV exists. So there's no difficulty on that. And we've done enough, we've placed all the relevant documents, resolutions on record, and the AG didn't have any further arguments on that. So I'm not going into it. So, well, I think I've covered, unless Mr. Prakash wants to supplement.
Yeah, I just need to supplement on behalf of my client, which is a petitioner BSCPL. Now, your Lordship has seen both show cause and the blacklisting orders also addressed to my client. Now, this is another extent of textbook abuse. Now, if your Lordship will see both the show cause and the blacklisting, your Lordship would appreciate that I have been mechanically dragged along in the entire thing. During the course of reply arguments, the learned AG cites one particular case. And according to learned AG, since I'm a constituent of JV, therefore I get naturally involved. Now, your Lordship kindly see that particular judgment. What he does that he has not read the fact. Now that judgment is clearly distribution. It's got nothing to do with the JV, where I am not the party to the contract. The party to the contract is JV. All the communications are being written to JV. It is a JV staff. In show cause, there is not even a whisper as to how I get into the picture. Who are my officers who have been involved in that? There are no whisper at all. Just because of that I happen to be one of the stakeholders. My friend has dragged me along with that, and I'm a company doing more than 10 to 15,000 crores of work, your Lordship. Now, kindly see this judgment which my friend strongly relies on by trying to substantiate that since I was a shareholder, and therefore by virtue of this particular judgment, I would also be dragged along. Now, before that, your Lordship, may I just first take you to the show cause notice? Because this is one of his law which I trained to try to advance, that since I am a shareholder, that is if one company becomes guilty of a particular act or offence, then the entire stakeholder and shareholder gets involved. Now, your Lordship will see there at page 61, my colleague can assist you, which is the show cause notice. The party 1 is my client, your Lordship. The party 2 is another joint venture shareholder, and the 3 is the joint venture entity, which.
One second, Mr. Prakash.
Yeah.
Yes, you're referring to which paper book? This is a.
No, in the first paper book itself, your Lordships can.
In the 23.
1186.
Yeah, 39 2024 show cause notice.
1186.
1186.
Page 1186.
Yes.
Lordship has it?
One second.
Oh, sorry, Malaj. It's 1078.
This 3924.
No, it's an annexure to something. No?
This is a reply to show cause.
Yes, yes.
It's
1 minute, Malaj. I'll just tell you, Lordships, in a minute.
I have 1078 annexure A.
Page 1078. 1078, your Lordship. So cause.
Yes.
Annexure A9, your Lordship.
Yes, A.
Yes.
Lordship will see, I am here, party number 1. And the third is.
1078, it was part of it.
Okay.
Yes.
Now, Lordship, if I just read, regarding acts of bribery, corruption, etc., my learned senior has already said, and even in the FIR, there is no case made out for bribery or corruption. If I read para 1, whereas a tender has been issued in 2010 under the Special Road Development Program, so and so, whereas a joint venture, para 2, of BSCPL, addressee, and so addressee name and style of BSc CNC had set up. The joint venture had been awarded a letter of acceptance in respect of the said project for a contract price of so and so. Now, if your lordship will see in the entire show cause, whereas the joint venture during the period of execution, para 7, sought appointment of dispute resolution board and raised claim in respect of payment due on account of additional bitumen level cess and all. And then they talk about DRB1, para 9, whereas the joint venture has invoked a dispute resolution mechanism for other claims. Para 10 again talks about DRB, para 11, whereas the joint venture invoked arbitration before the tribunal, before justice so and so. Para 13, whereas during the course of arbitration proceeding, instances have come to light from the cross-examination of an official of joint venture. Now I show you what they say in the show cause, my official, which culminated in so and so, and para 13, whereas such more glaring instances, so they refer to the books of account or the vouchers relating to the joint venture entity.
Yes.
Then they refer to, in para 13, your lordship, at para 14, in fact, two specific clauses, or one instruction to bidder. My learned senior has already argued that was in relation to the bid, and if there are any fraudulent act for seeking the bid, and thereafter they refer to clause 59.2, which is a condition of contract, which is an event of termination. And these contracts is where joint venture.
Last paragraph also. Last paragraph also.
Yes.
That is same last independent power.
Yes. The above said act of corrupt practice in execution of project are duly covered under the heading of fraudulent practice, and moreover, I will not go further on this because I am currently only arguing that BSCPL cannot and could not have been dragged along mechanically into this entire blacklisting saga. Now your lordship will see the para 17 of this show cause. You are hereby called upon to show cause within 15 days the receipt of this notice upon you as to why the addressee should not be blacklisted. Now your lordship, I may just refer to a judgment which my learned colleague has, my learned senior has cited. And this is the judgment where a legal position has been laid out that what should constitute in a show cause, particularly in a blacklisting matter. Lordship may just refer to UMC Technologies versus Food Corporation of India.
Yes.
This is the 2021, the Honorable Supreme Court judgment. And I will just quickly refer to two paras of the judgment. One para 20, which deals with the contents of show cause. And I'm requesting your lordship to see in perspective of BSCPL, my client, that where have they referred and where have they said anything about my client.
No, para 13 and 14. Para 13 and 14.
Para 20, your lordship.
20.
UMC Technology. Para 20.
Yes.
In the present case, the factum of service of the show cause notice dated so and so by the corporation upon the appellant is not in dispute. Rather, when Shri Banerjee has argued on behalf of the appellant that the contents of the show cause notice were not such that the appellant could have anticipated in order of blacklisting was being contemplated by the corporation. Gorkhas, then they refer to Gorkha Security Services. What is more important, I will just keep the balance, your lordship, is the subsequent paragraph, your lordship will see italics at Placetum C, contents of the show cause notice. There the law has been laid down that what should be the contents of the show cause notice. The central issue, however, pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind the serving of show cause notice is to make the noticee understand the precise case set up against him which has to be met. This would require the statement of imputations detailing out the alleged breaches and defaults he has committed so that he gets an opportunity to rebut the same. Another requirement according to us is the nature of action which is proposed to be taken for the breach. Now, your lordship, can we come to the last paragraph after Placetum G? We may hasten. Now, that's where the law is being done. We may hasten that to add that even if it is not specifically mentioned in the show cause notice, but it can clearly safely be discerned. That is about the practicing lottery. I may skip para 21 lottery. Para 21. Thus, from the above discussion, a clear legal position emerges that for a show cause notice to constitute the valid basis of a blacklisting order, such notice must spell out clearly or its contents be such that it can be clearly inferred therefrom that there is an intention on the part of the issuer of the notice to person against the notice. There are two aspects. One is that the valid basis of the order should be spelled out, and second is to intend to ultimately blacklist it. Your Lordship has seen the show cause. I'll show you the blacklisting order also. There is not even a whisper against this particular petitioner. Not a whisper. And what they do, Your Lordship, when they are asked to file a reply in affidavit, they now try to explain everything and make an attempt to issue another show cause by way of a reply in affidavit. Their position is that you being a constituent to JB, you will be held responsible and you are a part of that. When Your Lordship question them, they rely on a particular judgment. And that judgment will not apply in this case, Your Lordship, if I may refer to that judgment quickly. They rely on TPF Engineering Private Limited.
Which case?
This is 2023 SCC. This is a case of TPF Engineering Private Limited versus National Highway Logistics Management. My colleague can help. This was one of the incidents that they relied on.
Their compilation, I think it is in their compilation also.
TPF Engineering?
Yes.
Yes.
Yes. Yes.
Lordship?
Yes.
Yes. Now, Your Lordship, come to para 25 in this judgment. Now, in this case, Your Lordship, the facts were totally different. Now, in this case, what has happened, there was an office memorandum. Your Lordship has para 25?
Yes.
The bills are cleared.
No, go para 24. The fulcrum of the dispute was whether the petitioner would classify as an allied firm.
Yes, so allied firm was defined in the office memorandum. There is no definition here on the joint venture entities or allied firm, etc. What has happened, Your Lordship, since the allied firm was defined, therefore, when the blacklisting order was issued, it applied to the allied firm also.
So you mean there's no general understanding for the term allied firm?
No, Your Lordship, if you see that...
Unless it's specifically defined like you see in this OM.
Your Lordship, it is like a related party under the Companies Act. Now, Your Lordship, you see there are many joint venture entities which have 6 shareholders or 6 different entities. Now, supposing Your Lordship might take a case where the joint venture is accused of a certain offences, which would not mechanically travel down to all the stakeholders by virtue of that. Now, this is in a particular case where in a contract and in an office memorandum, allied parties were defined. Therefore, there was no way the entire judgment says, since the allied parties were defined, therefore that the other subsidiary or affiliate will be treated as one of the party and blacklisting will apply to them. That was the issue. Here the issue is, Your Lordship, all through the arbitration until now, it is a case of a contract between the joint venture entity which has its own independent legal status and the state and the stakeholder, unless they had specifically imputed the charges against me in the show cause notice, which would have given me an ample opportunity to defend my position, then the blacklisting order would have been valid. Your Lordship has seen from 2 aspects. One is as a constituent of the joint venture, and second is that the show cause completely silent on me, not a whisper. And if that law is to be propounded, Lordship, then every company will be mechanically dragged along. There is no concept in law of dragging along of a third party into something where the party is not responsible. And more so important that there is not even a shade of accusation on me.
Yes.
Malats, may I just supplement one thing, Malats, I wanted to point out in the show cause notice itself. If your Lordships now turns again, page 1145, your Lordships were reading, the crux of the show cause notice is para 13.
1145 in your paper book.
Please, my lords.
But are we looking at BSPL?
Very well.
10s,
in that, para 13, if my lords will see para 13 of the show cause notice.
Yes. Whereas much more
glaring instances. Now, whereas during, please see para 12, during the course of arbitration proceedings, instances have come to light from the cross-examination. Well, see, that cross-examination is seen. If my lords will see that cross-examination, you lords have to take my paper book for the instances of the cross-examination. It happened sometime in August 2022. And that cross-examination did not, with the greatest respect, my lords, did not reflect.
That is page?
Please, my lords, I'll just give you lordships in a minute. 469 it starts at, my lords. Page 469. It's a transcript of the cross-examination. Page 469, Annexure P26. Next is page 470.
Evidence on behalf.
Yes. Now all of this, let's page 471, page 472. The relevant portion is page 474.
At question 226.
Correct, 225, 226.
Yes.
Kindly see page so and so. Being cash paid to Chakradhar manager against purchases of wine bottles. Is it correct the claim is categorized the above expenses of business promotion, which as per understanding is meant for handling local issues? The suggestion is not that it is a bribe. Then see page 226 has included frivolous expenses. Donation was carried out as per a CSR corporate. Well, each of these matters is put to the witness. So today they're relying on this to say now the cross-examination shows us it was corruption.
Yes.
There's not a whisper, my lords, not a one suggestion to the witness that there is any bribe of any official for any favor. And I pointed out, my lords, some of the CSR work was because the local administration needed it.
No, the thing is that the direction of the questions at time was whether these expenses were used to inflate the claim amount.
That's right. That's a very different thing, my lords. Now you're using that stock phrase, corrupt and fraudulent practice. Now if your lordships comes back to the para 13, after setting out all those entries, they make a conclusion that all of this shows beyond doubt. They've already made up their mind just by looking at those entries. If your lordship sees the end of para 13 of the show cause notice, in mine it's 1145. I don't know what it is.
13.17.
Yes, my lords. In your paper book, my lords, the other paper book it's 1080.
Yes. 1080.
In mine it's 1145. The end of para 13, your lords should see.
I'm having your paper book now.
Okay. In my paper book 1148. 1147. So sorry, 1147. 1147. 17 entries are set out, 13.1 to 13.17. In fact, some of those entries, if I may read, 13.4, cash being paid at Hotel Polo Towers for celebration of Engineers Day of PWD Department. How is this a bribe, Manoj? How is this a fraudulent practice? Cash being paid towards Bamboo Hut Assistant farewell party with PWD staff. If it's a farewell party for my own people and they called for that farewell party, it amounts to bribery and corruption. Well, what I'm saying is they've set randomly, they picked up some 17 entries, and in the end they say the aforesaid details leave no scope of doubt. No scope of doubt that you address is engaged in corrupt and fraudulent practice. Well, the allegation is so easy to be made. That expression corrupt or fraudulent has weighty meaning in law. And if you don't follow it up with any invocation of the PC Act, how serious are you about? You're just casually making these allegations. Even here, my lords, they don't tell us whom did we pay the bribe to. There has to be bribe taker. They should say we paid bribe to that ex-chief engineer. There's no allegation. So what am I supposed to meet? If you make this kind of a vague allegation, I can't meet it. I can only deny it. So, my lords, the case law is very clear. Even though you may have an inherent power, you cannot misuse it. And, my lords, the final show cause order, which is what is impugned here, that's Annexure 1, that blacklisting order. Now, your lordships will find instances quoted here are beyond those 17. Please see page 46 now. I'll come to the bottom of page 45. Whereas instances have come to light, your lordship says the bottom of page 45. If your lordship sees financial year 2014-15.
Yeah.
Now, this 17 is what they set out at the show cause notice. It ends in the next page middle, 1.17. The same 17 entries. Now they add a whole paragraph. Whereas business promotion account for financial year 15-16 also showed. This entire discussion on 15-16 is not part of the show cause notice. So they rely on materials which do not form part of the show cause notice.
Yeah, that judgment, that techno, right?
Yes, technoprint, my lords, is a full answer to this, that it's an absolute abuse of the powers of the state and to bring out a very drastic result. Well, it's all well and good to say we have to stop corruption. It is all good and well and good and to say there is no time limit for proceeding against corruption. There is no limitation. Whenever one fine day I find there is corruption, I can start. But you have not started. In your FIR, your non-invocation of the PC Act shows you are not serious about this. Till date, Malak's not a single bureaucrat arrested. Nobody arrested. With the greatest respect, Malak's, 1 year has gone by, no charge sheet. So it is good that that kind of an allegation is good for a blacklisting order. But it won't stand even 2 minutes a test in the criminal court because there is no material.
See, what's alarming is only that, see in page 47, second paragraph.
Yes.
That's where what they've written here. And a contract of 1330.
That's what. I'm glad your lordship pointed it out.
Excessive sound here.
No, so Malas, that I wanted to.
1,000 crores.
Yes.
You know, that they are pointing, saying that these kind of activities
so that
contributed to.
I'm glad I was going to come to that next.
Yes.
I want to start with this, Malas. MORTH has to approve every bill.
Right. Yes.
And there's a huge scrutiny that happens at that level, at the central government's level. If your lordship sees page 757 now of this, my paper book. Page 757. I've just given you a sampling of an order that is passed, usually when bills are sanctioned and payment is released. It's just a sampling. Every such order sanctioning payment will have these words that they obtain sanction from the President of India. It's in the name of the President of India because it goes to the ministry there, my lords. It has to pass at various levels. It's not as if I can simply inflate a bill here and it will get cleared in the New Delhi. So which is why I'm saying, my lords, these allegations have to be made very responsibly. They have to explain to your lordship the entire procedure involved in sanctioning a bill. If this project cost went up, it is not that I suddenly added a few zeros and everybody agreed. It doesn't work like that. If my lords will see, what's the page please? 727. Page 727, Annexure P31. Your lordship sees right on the top, Government of India, Ministry of Road Transport and Highways.
Yes.
I am directed to refer to the arbitral tribunal about so and so and subject to it and convey the administrative approval and finance action to the President of India. So MORTH has never challenged. They tried to make MORTH a party to the arbitration unsuccessfully. Bills, my lords, have to be sanctioned at the highest level. If you are alleging bribery and corruption, if you are saying, look at the project cost is 1,300 crores, it has gone up. It's not that it was my whims and fancies. At so many levels, including the state government, my lords, at so many levels it has to pass scrutiny. You have to make then everybody a party. You have to explain what is the full chain. You have to trace the money trail has to come, Malads.
What's happened with the investigation?
Yeah, my lord, it is going on, my lord. Even ED has summoned. ED summons are also there.
This is the problem, Malads. One will lead to the other. This is every hearing. This is the problem, Malads. They get. It's so easy to turn agencies onto a person. This is what we were apprehending throughout. If one tap, if Lordships closes one tap, they will open another tap. After this ED tap, there will be an income tax tap. There will be a CBI tap. Well, there is no end to this. If you want to harass.
When did it start? I mean,
my lord, they have this summon to my chief engineer. Kindly pass this.
This is endless.
Is it to your knowledge?
No.
Because this is
even Malas, I must point out, even the show cause notice was not to our knowledge. In the arbitral tribunal, they annexed it to an application for the first time.
It was never served on you.
No, never served. We didn't make a noise of it because anyway, ultimately we had to face the proceeding, give them a reply. Because once it was annexed to the application, we couldn't have said, no, I have not received it now. But never formally served on us. This is what happens every time. Malas, if this matter were to go to one more hearing, I am sure he'll come up with one more summons. 100%. There's no end to this. Malas, I think this is itself an ample demonstration. I am thankful to my learned friend. Ample demonstration of the misuse of the agencies. Ample demonstration. Well,
even EDs are also under our
today
control,
business entities in this country, Malas, this is an unsaid grievance.
MORTH officials have also been named by the arbitral tribunal that their conduct is also not ever.
No. How do they know that, Malas? With this, the whole problem.
The 1288.
It was all behind the back of those officials.
1288.
These people will give a name to the arbitral tribunal. The arbitral tribunal will name them. Well, will your lordships accept that? You can name anybody. That person has no chance of coming and defending himself or herself.
1300 crore has become 2400 crore.
This is the only argument, my lords. This is an argument of prejudice.
About 400 crore.
This is an argument of prejudice. It's so easy to stand up and say this, but not to back it up.
No, like I was saying, that's the only thing that.
That's the only thing.
That's only alarming that.
But it's not alarming, Malas. May I say with the greatest respect, there are so many projects across the country. When the project gets delayed, inflation comes in, bills do go up, Malas. And this project overran its original time estimate by 4 years. It's bound to go up. Wages will go up, petrol costs will go up, everything will go up. Malas, transportation will go up, raw materials will go up.
This is the summons to the
That's right.
To my chief engineer to give evidence.
And how did he get it, Malas?
Because my chief engineer.
I'm just surprised. I'm just surprised that they seem to be fully in it. They seem to be fully part of it. Malas, this, I think your lordships will take note of this.
We have to support the investigation.
No. Malas, I don't need to now get into the lecture of what happens for between state governments and central government when they're different parties. The AAG knows that perfectly well. Malas, let's not get into this at all. With the greatest respect, these are all arguments of prejudice. Malas, merely keeping 1300 crores and 2500 crores side by side. Don't tell us that everything is corrupt and fraudulent practice. Well, it's unfortunate.
No, that is not what the court means.
No.
Well, I think that's only that we have to satisfy ourselves.
No, I'm satisfying like this, Malas, that MORTH has to approve every increase in cost and every bill, Malas. No, because they are paying for it. They are the ones first paying it, Malas. So they will not pass a bill. Well, I'll have to bribe how many officials? I mean, there's no limit to this.
I think anything else?
That's it, Malas.
But this particular aspect of 1303 going to 2400, that is their headline of story that they are propagating everywhere. The 1303 was the original contract price. What happened thereafter, they realized that there are certain more quantities of work that are required to be executed. Now they, at their own instance, got 4 supplementary agreements executed. These caused their case before the arbitrator is that all this 2400 has already covered along with the prolongation cost within this supplementary agreement. Now look how dishonest they are. Before arbitral tribunal, they said that this money which has been paid is the total money that I was entitled to. Nothing beyond that, because they were contesting my the prolongation claim. Here, what they are trying to now say after this, that 1300 gone to 2400. Now I tell you how it happens a lot. The department realized that there are quantity of works that has to be added more. They get the supplementary agreement executed. Based on that, they prepare a revised cost estimate. They prepare a cost estimate, which is prepared by the PWD, their own staff, their own engineer. It is not, I am not at all involved as a contractor. After that, once they have prepared the cost estimation, justification, explanation, they send it to MRTS. MRTS then review it, evaluate it, examine the entire aspect, then they grant the sanction.
No, the only concern, the thing why it's like a red flag is because it's public money. That's the only thing. That's all. That's all. The court
1287, your lordship. One paragraph, your lordship.
Absolutely, Justin.
1287, your lordship.
That is all.
Page 1287, one paragraph.
Circumstances leading up to it, maybe there can be n number of circumstances.
Yes, my lord.
Correct. The only thing is that the quantum of
yes,
the jump,
my lord. Kindly see one paragraph.
Absolutely.
The antenna goes up because of that. The answer to all argument is in one paragraph at page 1287 of paper book, your lordship. 1271.
Yeah, let Mr. Prakash finish. He's got bad audio. Yes. Yes.
There is one more perspective, lordship, so far as I am concerned. My learned senior has taken your lordship through the show cause order, the blacklisting order. Your lordship will see how generally they are using it. They are saying JD and its partner alleged it. JD and its partner have done. There is not a shred of imputation against the partner. No case has been made out. Therefore, my case is, your lordship, this completely fails the criteria laid down in UMC case, which is the fundamental criteria to protect the principle of natural justice. A specific case should be set up in the show. No case has been set up so far as I am concerned.
Yes.
1287, your lordship, kindly see. 12.
We can conclude today?
Yes, yes.
That will be 1287, my lord.
Yes.
Paragraph 191.
They are reading the article law.
I am reading. Let me, if my friend will not allow me to read.
No, let him, sir.
My
Mr. Prakash, let him.
My friend
Mr. Prakash, let him read it.
Will be jumping from his chair now. 191. It is true. Your lordship got page 1287, paragraph 191, your lordship.
1287 from which paper book?
12.
You're reading from BSc, I think.
Yes, my lord. The other one.
You're reading from the BSP, I'm sorry.
Yes, my lord. The Justice Muralidhar.
Yeah, well, it's my paper book. It will be, I'll just give a lordship in a minute.
1287, my lord.
No. Yeah. In my paper book.
Highly confusing.
Page 1349, my lords.
No,
in my paper book, 1349. Para 181.
I'm 191.
Okay, I'll give you the right page. Page 1354, my lords. 1354. Yes.
It is true that there is no specific plea by the respondent in SOD regarding the corruption angle. It was also not made at the time of decision 21. However, arbitral tribunal is duty bound to see the papers presented by claimant in the statement of claim, especially when they are brought to our knowledge. Despite such knowledge coming to the fore, claimant's written submission remains silent on the issue. Obviously, claimant has nothing to say on all such vouchers, register and details, and even at some point name of the government officials who have gotten the favors. There is an extensive list favoring engineers, DRB members, MORTH officials. Such payment clearly indicate connivance between engineers and claimant, as noted by the Honorable High Court of Meghalaya in order of 9/5/22. The tribunal has already taking notice of FIR, which has registered at the fag end, that too without any
rejected taking notice.
Yes, but the voluminous records presented in SOC cannot be ignored. So FIR is not taken into consideration. Voluminous records in SOC. Now kindly, my lord, see. Thus, by 194, the arbitral tribunal has no hesitation in observing that such documents do show connivance of the claimant with engineers on the site. Even MORTH and DRB are also not beyond.
With the greatest respect, how can a tribunal go this far with no material before it? And 1 minute, Mr. Prakash, I'm addressing the court. Mr. Prakash, I'm addressing the court. Mr. Prakash, please let me.
One at a time. Yes.
Mr. Prakash, please let me address the court.
Yes.
Well, it's with the greatest respect. These are completely beyond the scope of the arbitration. Well, this was introduced in the last minute.
No, we've noted that.
Yes, and MORTH, DRB, everybody is brought in by the tribunal. They are not before the tribunal. You can liberally make accusations against all of them.
226 of the arbitral law.
What is this? And I'm surprised he's relying on this, my lords. I'm very surprised he's relying on this.
Yes.
226 also, your lordship.
He's really involved. You have to be passionate about your cases. Yes.
The so-called verification, as Milord, paragraph 226 of the arbitral award, Milord, which page?
Yeah.
1365. Milord.
Well, I'll have to reply to all this if he's going on like this.
Milord, I just wanted to flag the relevant paragraphs, including the contents of so-called.
You give your notes on submission.
I will give my notes.
I don't think I can collate, whatever.
Yes, I'll put it.
I'll only say this, my lords.
My notes are getting jumbled up.
I have challenged this award before the appropriate court. He has challenged. I don't know why he's relying on this award to support a show cause notice.
No, it's just like how many arguments.
So the award comes after his blacklisting award. His blacklisting order is before this award, and he wants to rely on this award.
And blacklisting order has not been at all referred in rejoinder argument. My order has not been referred. And their contents are there. I will place that. I will place it.
Place our written notes of submissions.
Yes, we just fix a date for submission of notes.
Yes, 1 week is enough for us.
No, at least
we'll be close.
Very well. Well, so opening day we'll file it, Malas.
2 weeks, your lordship.
Yes, submissions are concluded. Parties pray they're allowed to present their notes on the submission. It's just after. We take a date after 2 weeks sometime.
Very well.
Any date.
I am obliged, Malas. I am deeply obliged.
These petitions have become voluminous.
Petitions are voluminous.
We don't have the advantage of digital, as a thing, e-filing. So it would have been better, especially when, writing the judgments, just managing the file.
Yeah, that's right.
You do better sometimes.
Yes.
The other matter is argued today. I think they filed how many the other GST matters. They filed on 10 compilations. So it gets
unmanageable. Really.
In Delhi High Court, I think Justice Muralidhar, you have introduced that.
No, I mean I've seen what Justice Muralidhar has done in Orissa and everything. Digitization of entire record. They have a whole building.
That's right.
We have got digitization and all. We have to have one day, Milord. We'll have to.
It's up to the General to.
That's right. If he wants, it can happen.
Because Orissa, I mean, the government is very cooperative. Correct. Especially when you were there.
That's right. That's right. Absolutely.
So I mean, everything we saw the presentation was done by just Panigrahi. I think one of our sessions.
Right.
So what is before and after?
Things have changed a lot. Things have changed a lot.
Yeah, but then there are many people still resistant to it. We won't name them. So that's the thing. I wouldn't MRH officials not name. So you might say they come to,
Pleasure.
Thank you.
Today you would be staying back, sir? No.